Good morning, everyone. Welcome to EDNA. Being 10 o'clock, I'm opening the hearing on Senate Bill 254, and I call Senator Rochefort.
Good morning, Madam Chair, members of the committee. For the record, my name is David Rochefort, a senator from Senate District 1, representing the top third of the state. Here to introduce my bill, Senate Bill 254, relative to controlled substance inventories. And I look at this bill as more of a technical correction rather than a broad sweeping policy change. For a little background history, I served on the Board of Pharmacy for 7 years. And during that time, we realized that U.S. law regarding controlled substance inventories in our pharmacy was in conflict with state law and created some confusion amongst various facilities in our state. And what we did, probably, if memory serves, about 4 years ago, we came to the legislature and asked the legislature to codify U.S. law regarding controlled substance inventories, which required that all pharmacies licensed in the state would have to do a full inventory of all the controlled substances every 2 years. Previous to that, it was every 2 years on an odd year. So if you read the bill, we got part of the problem solved, but we never struck the other part of it. So the federal law does not require every odd number year. We achieved our purpose in adopting federal law, but I believe this was during the COVID years. We missed the striking the every odd number year. So that's all this bill does. It's still required, doesn't change anything as far as controlled substance inventories in our facilities. They still have to be done every year, or excuse me, every other year, but there's not a designation that it's every odd year. So it fixes a mistake that we found when we got this bill passed a number of years ago, and pretty straightforward. So I would ask that the committee would adopt that and pass the bill. And I'm happy to answer any questions.
Thank you. Are there any questions? Representative Sellers.
Thanks, Madam Chair. Senator, I'm just kind of curious. Every even year, every odd year, you got to do it every other year
It
anyway.
has to be every other year, but so if you have a pharmacy that opens in an even year, and that's when they start business, they would have to do it in that even year, and that way it would clear up that confusion.
Follow up?
Thank you. So basically, it's pharmacy by pharmacy. It's not a statewide saying, all right, on the even year, all pharmacies are going to count.
Correct. It's pharmacy by pharmacy. So when a pharmacy board inspector goes in, one of the first things they ask is, show me your inventory. So it will be, as long as it's within that every 2 years as defined by federal law, they'll be in compliance.
All right, thank you. Any other? Representative Saitek.
Every time I think I understand it, you say something and I don't. Federal law requires pharmacies to be inventoried every 2 years.
Correct.
Because the federal law does not say whether it's odd or even.
Correct.
And this state law that you're proposing, this bill will allow every 2 years, whether it's odd or even.
Correct. It aligns with federal law. Exactly.
Thank you.
Yep, you're welcome.
But I would suspect, Senator, that at this point in time, nearly every pharmacy is doing it in odd numbered years because of the previous law.
Exactly. Yes.
Okay. Any other questions? Representative Leon?
Thank you, Madam Chair, and thank you, Senator. So essentially what this would do would be for any new pharmacies to make sure that the record keeping is straightforward and they don't need to add an extra hurdle because of a couple extra words in our law, correct?
It provides clarity for the pharmacy. It provides clarity for our inspectors. It provides clarity across the board. Exactly.
Okay. Other questions? Representative Saitek again.
Here I am again. Suppose you wanted to switch from every other odd year to every other even year. Could you do 2 inventories in a row and get your?
Yeah, that would satisfy the requirements of
Okay.
the law. Yes.
Yeah, that'd be the easiest way to do it.
Yeah.
Anyone else?
And if I may, in the reality is, in this day and age, most pharmacies are doing inventories much more frequently than every other year due to the strict controls that we have to abide by.
Yes. And this is strictly an inventory of controlled substances?
Correct.
Okay.
Yep.
Yes, you wouldn't want to lose track of those things.
And if I may, Madam Chair, I know that there's a non-germane amendment coming on this bill after this. I've reviewed the amendment. This doesn't change obviously the intent of the underlying bill. I have to admit, I'm not all that familiar with surrogate parent laws, but I don't have any objection to the non-germane amendment.
Thank you. That's good to hear. Representative Sytek.
One for the road, Senator.
Yes.
How much can you slip in your inventory? How much can be unaccounted for before there's trouble?
I mean, that's defined in rules, in the State Board of Pharmacy rules. I don't have that off the top of my head, but there are things called like major losses, minor losses, and there's various reporting requirements for each one of those things. So if you're looking for some reading, you can some captivating reading, I'm sure.
Yes. It's always amusing to complete an inventory and you realize that you have more than you thought you did.
That's a problem. Yes.
All right. Anyone else? Thank you, Senator.
Great. Thank you very much. Have a good rest of your day.
Thank you. Does anyone else wish to testify on Senate Bill 254 before? Okay, please give us a card and come on up. Yep. All right.
Good morning, Madam Chair, members of the committee. My name is Elizabeth Sargent. I'm here today. I work for Champaign Capital Group. I'm here today representing New Hampshire Pharmacist Association and New Hampshire Society of Health System Pharmacists. Health system pharmacists are pharmacists in hospitals. And to be honest, I've just passed around. Caitlin could not be here representing NHPA, but we submitted her written testimony in favor of this bill. And I just confirmed what I've represented pharmacists for a long time, and they always talk about, they do these inventories constantly, all the time. So this is just to match up with the feds. So I think Senator Rochford was the expert who could have answered any questions, but just wanted to get on record, we support the bill.
Thank you. Are there any questions?
Thank you so much.
Okay,
Thank you.
seeing none. Does anyone else wish to speak on Senate Bill 254? All right, I will close the public hearing and we have a few minutes before we can have the hearing on the non-germane amendment. Okay,
I'm still waiting on the amendment for
That's
the
fine.
LNA.
all right, then
clarification.
perhaps we could discuss,
Oh. Sorry, I was speaking to an amendment to one of the bills we heard yesterday. We needed to fix some commas and an effective date. And yes, I guess while we're here, everybody should have the non-germane amendment in your stack of Senate bills. I handed it out at our session previously. But as to these ones, I don't have the amendment for 93 yet.
all right, but we won't do 93.
We want to discuss any concerns with the physician associate one, or see if there's any concerns on the cosmetologist.
Yeah, why don't we discuss the PAs? All right.
Some of us don't have the non-germane amendment.
Okay.
Got lost in the shuffle.
I put them on each seat, but I had a few extras. Thank you. You're welcome.
I'll get, yeah. Do you want to lead the talk? I want to get my copies.
Okay. So on the physician assistant and physician associate, there was a study committee on PAs and looking at everything surrounding them last term. I was actually I'll open an executive session on Senate Bill 285 so we can be official here. So I was on a study committee last year about PAs, looking at the laws, looking at the scope of practice, looking at everything that that regulated them and was in the statutes. It was intended to look for any future legislation regarding PAs. And the only conclusion from that study committee was that as there is an evolving name change to physician associates from physician assistants, that putting in a bill to change the name in our statute from physician from a physician assistant to physician associate would be good and helpful for the industry and the profession. The bill that we have in front of us, would make that name change, but would not require anybody to call somebody by the name physician associate. So most physician assistants, most PAs are employed by hospital systems. If their employer wants to keep referring to them as physician assistants, there is nothing in the law that would impact this. This is just cleaning up the language to standardize it with the way that the industry is headed, and would allow any of the programs in New Hampshire to name themselves as physician associates. So this is a benefit for that community. If it had been a problem for any of the providers, they would have come and told us that it was a problem for their hospital system, but we did not see that. So if there's, I don't know if there's anybody who has any thoughts or any questions on it. Representative Sellers?
Thank you. There's no scope creep or anything like that, from going from a PA to a PA.
Correct. There's no change in scope. There's no change in practice.
Okay. Any other Representative Rees?
Yeah, we received something from via email from the Northeastern Society of Plastic Surgeons and the American Society of Plastic Surgeons in opposition to Senate Bill 285. And they seem to have some objections about it, that the name change from assistant to associate would blur the lines and impact the transparency with for the patient. So I don't have a hard opinion on this. I'm just curious about that. I responded, but I haven't heard back yet. Do others share the concern that that association does, that there's a lack of transparency and that it will be somehow misleading to the consumer?
Thank you. I've been involved in this issue since last year. There are some other medical professionals who do not want to change the name. Some of that is I'm not going to attribute anything to the plastic surgeons or anybody in particular, but some of the discussion we had heard showed that they saw them in a role that's smaller than their actual scope of practice. So when you're looking at some disagreements between different professionals within an industry, sometimes there's some disagreement about what people should be called. And I appreciate that the plastic surgeons have an opinion on this, but I don't think that this would impact the patients, because if you're working for a hospital system and they want to keep calling you a physician assistant, they can. This just changes the title in the law.
Okay.
Representative Long had a question.
Yes, just a quickie.
I just wanted to say that I do not share those concerns, because I don't think the average patient really knows what the position is anyway, so there's not a lot of opportunity for confusion. And I am probably more educated about medical positions than most patients, because my parents are both nurses, but even I didn't know what a physician assistant was until maybe 4 years ago.
Are we in executive session?
No, we're just having a discussion.
sorry.
It is now 10:15, so we will pause in our discussions.
I had actually thought that we needed to be in one to discuss it, so I had opened an executive session,
Oh,
which
in
we
that
can now
case,
close.
we will close the executive session without taking any votes. I'm opening the hearing on the non-germane amendment to Senate Bill 254 and recognize Representative Leon, who is the sponsor of the amendment. And I hope you will explain to us what it is.
I don't seem to have the amendment. Okay, thank you.
Thank you, Madam Chair and members of the committee. For the record, I'm Erica Leon, representing the town of Derry. This amendment, non-germane amendment, is intended to fix a problem with the statutory language on FBI background checks for the Department of Education. The statute had been updated in order to allow these background checks. However, the language was rejected by the FBI. This is a change at the request of the Department of Education so that the surrogate parents, who are the people who make some medical decisions, and I'll leave it to the department to clarify that, so that people who are in charge of making decisions on behalf of children can be FBI background checked and can do the role that the state is asking them to do. So I introduced this as a non-germane amendment on this bill because it seemed to be a necessary and pressing need, and one that made sense to come through our committee. And so here it is, and I will let the Department of Education give more information on it, but I believe that it's important to make sure that we're at least a quick follower as the FBI is, we're trying to figure out what language the FBI needs for these background checks.
Okay, do I understand you correctly to say that the background check is in current law and this merely updates the language to that we worked out with on other bills? Is that correct?
That's correct.
Okay, thank you. Does anyone else have a question? Representative Broda?
So as I recall, the other background check language that we had in like House Bill 82 was significantly shorter than that. So I just wanted to be sure what the differences are.
Thank you. The language that we had in 82, I believe was language from the Department of Education, which had been successful. I believe that was our process there, and this is it was not. It was from another area. So that this is the language the Department of Education has reviewed and they believe will be successful.
Follow up?
So the language that we have received for the previous bills that had to do with OPLC had been from the Department of Safety.
Okay.
So you're saying that this language comes from the Department of Education.
Yes.
So I'd like a comparison as to what the two are, but we can do that on our own.
Okay. And we can actually, we can probably ask our committee researcher to compare the two for us.
He's agreeing. We will get that comparison.
Thank you.
All right. I think one difference is that if you look on page 2, it specifically lists various crimes that will invalidate people. I mean, these things do not necessarily invalidate a license, depending on the license.
And within the Department of Education laws, I had previously served on education, and there are a lot of other specific carve-outs like this that you wouldn't have as a carve-out for a general profession, because when you're in a school, there are certain disqualifying conditions that you may not need in plumbing.
Okay, thank you.
Thank you.
Do we have anyone else that cares to testify in this amendment? Yes. Representative Schmidt, you had a question?
I do, Madam Chair. Thank you very much. And I apologize for being late. So you were saying earlier that this specific language has been recommended by the FBI?
It's been recommended by the Department of Education as they've worked with this. The Department of Education's lawyer is here to provide greater information. The Department of Education's lawyer is here to provide more information on this and this is a result of them trying to work through the denial with the FBI. So she can provide more information than I can.
Okay,
Thank you.
thank you. Ms. Fenton? My goodness, we have the whole team. We'll take your pink cards once you've spoken. No, these are for the bills. None of those.
Good morning.
They gave us pink cards. Not taking a position.
Ah, excuse me. I messed up. This is Diana Fenton from the Department of Education and Christine Shea from the State Police. and Janet LeBlanc from the Department of Education. Thank you. All right.
Good morning,
Sorry about
members
the
of the
confusion.
committee. Thank you for your time. My name is Diana Fenton. I'm an attorney with the Department of Education. I'll let the people sitting next to me introduce themselves as well.
Good morning. My name is Janelle LeBlanc. I'm an education consultant in the Bureau of Special Education Support at the Department of Education.
Good morning. I'm Christine Shea. I'm an administrator with the Department of Safety, State Police Criminal Records Unit.
We appreciate your consideration of the non-germane amendment that is before you for consideration this morning. I would like to draw your attention to the document that was passed around. It is RSA 186C:14 entitled Surrogate Parents. These are educational surrogate parents. Janelle can speak to you more about what that program entails, but I want to draw your attention to Roman numeral 3A. The law before you was passed in 2023. That law was already passed, giving the department the ability to complete a criminal background check on an individual who wants to serve as an educational parent. It was based in part on other areas of the education statute where the department has proactively sought areas where we conduct background checks on individuals who want to teach. For example, RSA 189:13A, the department plays a role in conducting a background check on an individual who wants a license to teach. The district also does a background check, but there is a list of statutory disqualifiers that would prevent a district and the department from allowing someone to teach. So that list of disqualifiers, some of those offenses are possession of child pornography, murder, kidnapping, human trafficking, anything that has a very strong link to child safety. Those disqualifiers are already in law. And so 186C:14 had a cross-reference to what the law already was. And working with our partners at the Department of Safety, we were seeking the federal approval of the statute that was passed in 2023. And we were informed this summer or fall that we did not get the approval. We asked for reconsideration, and that was denied. And so that is why we sought out a bill to put in the corrections, really technical corrections, so that the FBI would approve the Department of Safety releasing the federal background check to the department so that we could complete what is already in law. We're happy to answer your questions. The three of us are here so that we can address any of the questions you might have, whether it's the law that was previously written, any of the federal background check requirements that the Department of Safety needs to work with, or any questions you might have as pertains to the educational surrogate program that the department oversees. And again, we appreciate your consideration.
Okay, I just wanted to make sure that this language, the state police believe this language will satisfy the concerns of the FBI, and so we can get this taken care of.
Thank you for the question. That is definitely our hope. We have asked from the FBI for further clarification on this, as well as many other language issues, as I know this committee has heard. And we don't get much clarification, unfortunately. So we're basing stuff based on looking at what other statutes have passed recently, whether it be here or with other states, what other states have run into with language issues with the FBI law unit as well. So that's kind of what we're using for guidelines. We know they want to be extremely specific, which is why the language got switched as it did.
Oh, thank you.
To add to that, if I may, the language before you in the non-germane amendment mirrors other areas where the department has been successful in having the criminal background check passed. And so that's why we feel fairly confident in the language that we brought forward to you. I don't think any of us can guarantee that the feds will pass it, but the department has been successful working with Department of Safety in getting criminal background checks passed for bus drivers and educators and teacher prep programs at the Department of Education. We're really proud of the work that we've done in that area, and that language mirrors other sections of the statute that have been successful.
Thank you. Is it a recent change that the FBI is worrying about the language in this detail? Because we've had criminal background checks in the law for decades.
Agreed. So what we're finding is there's new leadership there, or was, I would say, within the past 2 years. So their restrictions, along with new employees, have been slightly different than they had in the past, because they even have the authority that if we send something that was previously approved, they could look at the language now if we're tacking something on and be like, no, we need to switch the initial language as well. So we've had many discussions with them. I go to many conferences and have one-on-ones with them to try to get further clarification, because it's a struggle for all the states. And we're just trying to be good partners with them as well as good partners here. And in reference to the successful language that education has had, that's what we're really using for our gold standard with other agencies. We're always referencing them to 189.13A and saying, mirror this as best you can, because we know that's been very successful. It's very clear and concise with the language, and we know that's what they're looking for.
Thank you. Representative Davis and then Long. Yes. Representative Leon, I think I will mention to the whole committee that we should not pass out amendments in advance because they get lost. All right, so your question. Oh, that one. Oh, okay.
Microphone turned on because.
All right, thank you. Representative Long and then Pearson
So I'm
and Schmidt, sorry. Excuse me.
concerned by the statement that this is just because of a change in leadership with the relevant office at the FBI. Because what happens if we pass this today and then tomorrow they get new leadership again? Are we going to need to change the law again?
Now, the only time that something needs to change is if we're making an adjustment to that state statute where perhaps you're saying it's going to a different person within that agency. That's a change that would need to be submitted to the FBI again. If it exists in state statute and nothing gets changed, it's fine.
Representative Pearson?
Thank you. If someone desires or is looking into becoming an education surrogate, do they have the ability to request this background check on their own ahead of time?
It's my understanding that they could pursue.
Use the mic, please.
Yeah, you kind of have to eat it.
Sorry. It's my understanding that educational surrogate parents could, but the stumbling block that we have currently is in the FBI's release of that result of that background check to the Department of Safety, which would then share it with the New Hampshire Department of Education.
Yeah, that's not what I'm worried about. What I'm worried about is if someone wants to find out what their background check is going to be before they go through the process.
Thank you for your question. I'm sorry.
That's fine.
What the FBI does is that any individual can request their own record through them, but for their own purposes. So if they were going to go for licensing, it has to come through Department of Safety.
Yeah, I get
But
that.
any individual is entitled to get their own record through the FBI.
Thank you.
Representative Schmidt?
Thank you, Madam Chair. So the question I have is surrogacy. I'd never heard of education surrogacy before. I hardly understand what surrogacy is all about, but at least it's something I have heard of. Education surrogacy is brand new. And the concern I have is that we're amending this thing, which is already relatively unusual, onto something about controlled substance inventory. Isn't this kind of like getting from here to Boston by way of Los Angeles? I just don't get the
Representative
language.
Schmidt, that's why we're holding this hearing. It is identified as a non-germane amendment, and as you said, it has absolutely nothing to do with controlled substance inventory.
Well, I understand that
We're
aspect.
making a Christmas tree, Representative Schmidt, which is not always the case, but we don't have another bill that would suit this better.
I'm not saying I'll vote against it because if it's a good idea, it's a good idea. The question is whether I mean, if this is the only tree we have to hang it on, even if it's not Christmas yet, but I just wonder whether it's coming. I don't have a problem with the,
Okay,
with
I
the
just
bill
wanted
itself.
to make it clear that this is not they just asked Representative Leon, find a place to put it, and she picked an innocuous bill with a high chance of passing, namely the controlled substance inventories. And as I said and repeat, it has nothing to do with that.
Well, I
It is
understand
totally
that.
irrelevant.
Okay, but
That's why we're holding a hearing. Representative Sytek.
It seems like there's something very obvious that the last step if has not been taken. If you can get your own record from the FBI, can't you just take it? Here it is. What do you mean no? I mean, here's the record. What are you talking about?
Representative,
So,
please answer that.
of course, I'd be happy to, and I'll look to the Department of Safety as well. My understanding is that the record cannot be further disseminated. And from the Department of Education's standpoint, the department would be remiss if we were to rely on someone handing their record to us. It could be stale. And the department, for purposes of integrity, would want to get that record directly from the Department of Safety to ensure that it is, in fact, an accurate record.
Thank you. Follow up.
Rubbish as far as I'm concerned, but okay. This is all being done to get FBI cooperation so that they will proceed with the background check that the state may not on its own be able to do. That's why is the FBI involved at all?
Because we need to find out if the person involved committed a crime in some other state.
Okay, so we want the FBI cooperation.
So the background check is comprised of two components: the state record, which is readily available, and the FBI background check, which is the nationwide search. In order for the department to ensure that an individual who wants to work with children is in fact safe to be around children, the department prides itself on saying we want both pieces of the record. We want the state and the national record. And that is where our partnership with the Department of Safety comes into play. And the language before you will hopefully address the gaps that were recently identified.
Okay, Representative follow-up.
Yeah, why don't you ask the FBI for what language they'd like to see? Will they give you model legislation? I mean, why are they being coy?
Okay, thank you for the question. But first, to kind of address the question before that, is pursuant to Public Law 92544, every licensing agency within this, which New Hampshire goes by as far as disseminating the FBI record, must come through us to be disseminated to us from the FBI directly. That ensures you are getting the certified record. There's no other handler in there. But also pursuant to our rules with Department of Safety 57300, I believe, it also requires that any licensing agency must get a fingerprint-based record through us pursuant to statutory authority approved by the FBI.
Representative Long?
Wait,
Go
what
follow,
about
you
the
have a
model-
follow?
What about the model legislation? That's,
So-
you answered the question before. that was
Right.
it.
So that is something that we have, as I've tried to say before, we've asked for time and time again. They're a legal law unit. So such as any legal law unit, we have that within the state itself. It has certain requirements in order for it to be passed. So that's why everyone's trying to stay within those parameters.
Representative Long?
When the police stop someone on the street, they have some level of ability to run a national criminal records check. And I don't know the details of that. So what's different about that versus this, and why can't you obtain someone's record through whatever process a patrol officer would use?
Okay, thank you for the question. It's a fingerprint-based check is what we're doing. So I can put on my application that I'm Christine Che, and then when they take my fingerprints, the FBI record comes back saying, you know, I'm Jane Doe, and now I have a whole record. So it doesn't matter what I say my name is, my fingerprints are going to tell the story. When you get pulled over on the side of the street, the system that they are using is not fingerprint based. They go by a name, but it can only be accurate at the point in which they take fingerprints.
Representative Doherty, you had a question? Oh, sure.
Thank you, Madam Chair, and thank you for taking my question. The 5 years validity term, is that a standard thing, or is that consistent with other requirements, or is it something special with this one?
What 5 years?
It seems like a long period of time to me.
Oh, there it is.
It's lines 14 through 16.
Thank you for the question. So I believe that 5-year period mirrors the original credentialing statute, the RSA 189 colon or 13A.
Yes. Okay, Representative Sellers?
Thank you, Madam Chair. If doing a criminal background check, I'm concerned that you're really only looking for certain items to make sure the person hasn't done X, Y, and Z, and they're going to be around kids that might be harmful. Why do you need to get the entire background check of a person with information that it has nothing to do with the position they're looking for? Maybe, for an example, a person would maybe stole something and did time in another state or something like that. You know, for an example, but it had nothing to do with hurting a child or anything like that. But you'd be getting that information from the FBI, and it has nothing to do with the education at all, or surrogate.
Yeah, thank you very much for the question. I think it's my understanding, because there is a long history of the department working with the Department of Safety to get criminal record checks for licensing educators, and that was an issue. There was a time that the Department of Safety would review an individual's record, and they would cull out offenses, just as you mentioned, that were not directly related to child safety. And there were a couple of issues with that. One, that was an administrative task that the Department of Safety made a policy decision they were not going to do because it didn't want to be held responsible for that if there was a human error. And from the Department of Education's perspective, there was a concern, and in fact, there was an actual case where someone had been charged with a really serious crime against children, and it had been pled down to something, a misdemeanor level offense, and that information was culled out or redacted because it didn't fit the parameters. And the department came before the legislature and said, we feel that it is important to see the entire record so that nothing slips through the cracks inadvertently, so that we don't have a situation where someone is able to harm a child again. And that was a policy decision that was made for our purposes, working with the Department of Safety.
And just to follow up on that too, where education and in this amendment as well, ask for a full confidential record, that's where they're getting the entire record. If that language is not in there, then they receive guilty onlys. So if a state, and not all states are keeping up with their dispositions as they should, has a case that doesn't have a disposition, we cannot release that because it's not a guilty conviction. So it's not part of the record that can go out. So that's why it's important with any, and we're doing it with childcare as well, with anyone that's working with children, that they're getting the full confidential record so they can see the whole picture, and the thought being that they can have that conversation with the applicant and just say, I see that there's a charge here, but we don't know what happened with that, have that conversation and ensure that they've got the right person for the job.
Follow up?
Thank you, Madam Chair. Okay, so part of my concern is loose lips sink ships, and living in a small state, someone might say something outside the realm of the confidentiality, and now you're getting information that really doesn't pertain to you at all, which could actually leak out. So my other part of the question is, especially on this, because the FBI, why don't they provide the exact language they're looking for so you can put it in once and for all, instead of you coming
Excuse
back
me,
next year and the year
Representative
after?
Sellers, I don't believe anyone in this room understands the motives of the FBI.
Madam Chair, I was just asking, couldn't they ask for that?
I believe they have.
We
She
have.
stated she already has.
I've tried.
Okay,
Thank you for
Representative
that. I
Rees.
have tried numerous times to have that conversation and all that.
And if I may, I want to further address your concern because the department shares that concern. And so I will bring your attention to the lines 18 and 19 of the non-germane amendment that does have the maintaining the confidentiality. We have the infrastructure by which to do that because the department is already taking on this function. We have this individual in our credentialing bureau who reviews the criminal records, stores the criminal records, and then the department shall destroy all criminal history record information within 60 days of receipt. So we have the infrastructure and the plans in place so that that information does remain confidential.
Representative
And-
Rees?
Oh, sorry.
Oh, sorry, go on.
Just to follow up on that too, that is part of why the language is so specific, and what we're trying to do with the state statutes now is the FBI is very aware of confidentiality and privacy, and that's why they are such sticklers about the language. And so you'll notice in any of the state statutes that we're doing now, who specifically is getting that record, because not just anybody can receive that record. It has to be an authorized recipient, an authorized agency, and anyone that is viewing a FBI record is required to go through specific CJIS training from the FBI as well.
I've got plenty. Thank you, Representative Rees.
Thank you, Madam Chair. I appreciate all the work that you've done to try and divine the thinking of the FBI, and sitting here in front of us and trying to defend the fact that the FBI is not providing this information. So the process that you have taken seems quite reasonable to me, to look at the language that has passed in other situations, and the sponsor has done this. My question is, so what we're trying to get to is making sure that there are surrogates who have passed background checks. How many surrogates are there in the state of New Hampshire that perhaps are being held up by the fact that this language hasn't yet been fixed to the satisfaction of the FBI?
Thank you for the question. So presently, the New Hampshire Department of Education has a network of about 110 volunteer educational surrogate parents. Surrogate parents are required by the Individuals with Disabilities in Education Act, IDEA. These educational surrogate parents act as parents on behalf of children whose parents are unknown, unable to be located, or they're in the legal custody of DCYF. In addition to a couple of other very niche circumstances. But so these individuals provide a service to these children and act as their parents in the special education process by providing written consent. So we have currently 110 that are certified with us. And we have a list of about 15 to 20 who have expressed interest in the program or who have submitted applications and willingness statements or at various stages of the process who we are waiting on this background check to pass.
Follow up?
Thank you. And in your experience, if people have to they offer to do something as a volunteer, it sounds like it's not easy work. It sounds like it's onerous and requires a certain level of knowledge. That these experts who are willing to do this work, if they are made to wait for 6, 9, 12 months, is the Department of Education and the state of New Hampshire and these children at risk for losing these 15 to 20 volunteers?
We would certainly love to have them, right, for recruiting and retention purposes. I think it is totally reasonable for individuals who have long expressed interest in serving in this capacity to become otherwise engaged while waiting for this process to be finalized. We are so incredibly grateful to the volunteers who have been persistent in checking in with us and seeing if we are able to move forward. So we're eternally grateful for their support. But anytime you're asking individuals to serve in a volunteer capacity, they have the opportunity to decline and say no, and the need of these children to have parents to act on their behalf in the special education process is certainly immediate and necessary. So having a robust network of volunteers is really important.
Any other follow-up?
Thank you very much. And I just want to express my gratitude for the 110 who are serving in the 15 to 20. Please stick with it. We will get this sorted out so that you can serve the best interest of the children in this state.
Representative Sytek.
When you get this background check, what about something that's nullified? What I mean by that is this child pornographer has it pleaded down to a misdemeanor A. In 2 years, if he's clean, it goes away. It's nullified. Do you, nullified or not, you've got a child pornographer that's applied. Is that, what is the status of a nullified conviction?
Thank you for the question. If a individual gets their record annulled or expunged, that's not a record that we can release.
Okay.
Other Representative Dargy.
Is there overlap between CASA and the surrogate parents, or are people frequently in both, or can you kind of talk about that a little bit?
Of course, thank you for the question. Yes, educational surrogate parents often work hand in hand with CASAs. CASA stands for Court-Appointed Special Advocate for children who are in the legal custody of DCYF. So CASAs advocate for children in a very holistic way in the eyes of the court, but they don't have the ability to provide legal consent, which is what the special education process requires. So even though a child may have a CASA, that individual cannot provide written consent in the special education process, which necessitates the need for an educational surrogate parent. So it's very common for a child's special education team would include both their CASA, who's there to advocate and contribute their knowledge of the student, and then also the educational surrogate parent whose focus is narrowly tailored to the special education process.
Any other questions? All right, seeing none, thank you very much for all the information. Is there anyone else who wishes to speak on this amendment? Okay. In that case, I will close the hearing on the amendment and open the hearing on Senate Bill 182. And Senator Prentice. or assistant. Thank you. Okay.
Good morning, Chairman McGuire and the members of the House Executive Departments and Administration Committee. For the record, my name is Kevin Condict, introducing SB 182 on behalf of Senator Prentice. SB 182 was filed at the request of the New Hampshire Department of Health and Human Services and addresses changes needed to the statute that establishes and governs New Hampshire's multidisciplinary committee charged with conducting comprehensive reviews of deaths that occur during or within a year of pregnancy, pregnancy-associated deaths, presently known as the Maternal Mortality Review Panel. This proposed legislation seeks to amend RSA 132:29 through 132:31 to update and revise the Maternal Mortality Review as follows. 1, change the name of MMR panel to Maternal Mortality Review Committee. 2, revise the definition of a pregnancy-associated death to include death of a woman while pregnant or within 1 year of the end of pregnancy, irrespective of the duration and site of the pregnancy, from any cause related to or aggravated by her pregnancy or its management. 3, specify the institutions administering and facilitating the MMRC, New Hampshire Department of Health and Human Services, facilitating jointly with the New Hampshire Perinatal Quality Collaborative affiliated with Dartmouth Health. 4, changes the committee membership, including a representative from the Division for Children, Youth, and Families and the Department of Corrections. 5, authorizing compensation for mileage. And finally, secured access of the MMRC and its abstractors to certain protected data. Members of the department are here to speak on SB 182 and to take any questions from the committee. Thank you for your consideration of this bill. I was asked to introduce this 5 minutes ago. I'm going to refer to them.
Well, I've been in that seat. We won't ask any questions, except Representative Sitek wants your name, I believe.
Yeah, okay, thank you.
Okay. Abby Rogers and Courtney Keene.
Thank you.
Good morning, Chair McGuire and members of the committee. My name is Abby Rogers. I'm the Legislative Liaison for the Division of Public Health Services. And we are here today to provide our support for SB 182. That was a great introduction on the fly. So he covered a lot of what we were going to say, but the Department of Health and Human Services Division of Public Health Services is supportive of SB 182. It is a department requested legislation which provides some clarification and minor revisions to RSA 132:29 through 31, which governs the Maternal Mortality Review Committee. These clarifications will provide clarity for the statute, allow us to update our rules, improve the functionality and critical work of the committee. We want to thank Senator Prentice for sponsoring legislation. I'm going to turn the bulk of the testimony over to my colleague Courtney Keene, who's the Bureau Chief for Maternal and Child Health. Thank you.
Good morning. The Maternal Mortality Review Committee is a multidisciplinary group of appointees who review maternal deaths that occurred during pregnancy, delivery, and up to 1 year postpartum. The MMRC only receives de-identified case information, no medical records or PII is shared. The purpose of the committee is to perform a comprehensive clinical review of maternal deaths to identify trends, risks, provide information on prevention measures, and disseminate findings. The MMRC members implement the recommendations based on the data to inform clinical care quality improvements, provider education, and perinatal interventions. The MMRC is committed to continuing comprehensive case reviews of maternal deaths, identifying the opportunities to eliminate future maternal deaths in New Hampshire. Thank you for the opportunity to provide testimony on the proposed legislation, and I'd be happy to answer any questions.
I have one minor technical question. Normally, when we create a committee, it is composed entirely of legislators, and is looking at the list of members, there aren't any. Wouldn't some other word be more appropriate? Council, I believe, that has no restrictions.
Thank you for your question. I think what originally when the panel was created, that was the federal recommendation to use the word panel. At this point, the federal recommendation is to use the word committee. But we'd be open to suggestions on anything that would be more amenable. Thank you.
Thank you. Yes, Representative Sitek. It's got both names on there. Representative Leon?
Thank you, Madam Chair, and good to see you again. I've missed you being in a different committee. My first question is on page 4 on lines 7 and 8. It strikes out the restriction from the chair acquiring and retaining any individually identifiable information. Could you help me understand the necessity for that since we're so protective of personal information in this state? It's page 4, line 7 and 8. It's just before paragraph 3 at the very end, if you don't have line numbers.
Yeah, the chair said that.
I believe that's addressed in lines 11 through 13.
Oh, sorry, that it includes.
Sorry, let's put this small print.
So I can answer that.
Sorry.
Thank you for the question. This statute was put into place in 2010. The chair does not receive any information related to confidential information. That's just a clarification and a cleanup, if you will.
Thank you. I'm sorry. Just that part just seemed
course.
very
Thank you for
important,
the
and I
question.
appreciate you catching that's in there. If I could have a follow-up.
Follow-up?
As a follow-up, has this always included abortion-related deaths subsequent to abortions as well, since that woman had experienced a pregnancy, or are those excluded from review?
My understanding is those are excluded, but I can follow up and confirm.
I thank you. I would really appreciate knowing that because I value the health and well-being of all women and understanding whether or not there's higher mortality rates. We're looking now at overdose deaths from women who continue their pregnancy or have a spontaneous abortion, which is a miscarriage. And I'd be very concerned to know if we were underserving a group of women because we're not looking at their outcomes from their pregnancies.
Thank you.
Thank you.
I didn't realize
Representative
that was-
Reeves?
Yes, thank
Follow
you.
up, yeah.
I'm sorry, could you clarify what exactly you were looking for there? Were you looking for spontaneous abortion or medical abortion or surgical abortion? I just want to be clear.
Thank you. My question is, this appears to deal with the death of any woman who had been pregnant. If women who have a intentional abortion are excluded from that, that's not a complete data set. And if we find that there's a higher overdose rate or other mortality rate for women who undergo a voluntary abortion, that would be important to make sure that when women are getting abortions, the appropriate care is provided and their health and safety are protected. Not to single out anybody receiving abortions, but to make sure that we're protecting their health and safety. Just
Yes,
the
I
way
don't
that we
see
do with
where
other
they're-
pregnant women.
I don't see where they're excluding deliberate abortions.
Just to provide some clarification, thank you, is that pregnancy-related death is within 1 year of postpartum, correct? That's how it's defined in our rules.
Okay.
But we're happy to take a look. Certainly, Representative Land, thank you for that comment.
Yes,
you.
we would not want to exclude women simply because they had an abortion.
Of course, yeah.
Any other questions, Representative Sellers?
Thank you, Madam Chair. Just to clarify postpartum, because I'm not a doctor.
It
Is
means
that
after
someone that's
birth.
delivered a baby?
Yep, that's someone who's delivered a baby for up to 12 months.
Thank you.
Okay, Representative Bailey.
Microphone.
Hi, in this testimony, the second bullet point says that you're revising it to delete the exclusion of accidental and incidental causes. How won't that affect the data collected going forward versus the past? I take it that means car accidents and bolts of lightning and
Thank you for the question. Yes, so to exclude, to update the statute from 2010, it basically is saying that pregnancy-related deaths from from an accident, from something that's not specifically tied to pregnancy or postpartum period would be excluded. Does that clarify
But
that?
now it's included.
Is that correct?
I will confirm and get back to you.
Won't that change the flow of the data?
Thank you for the question. So yes, so what we're updating is the CDC's recommendations on what is to be included. And in the definition of pregnancy-related death, it does include, it will to include overdose deaths. But we can get back to you specifically on, on the specifics of your question. But we definitely wanted to have overdose deaths included in our review.
So follow up?
Follow up?
But do you somehow, when this data is being presented, do we have an asterisk saying there's been a change in how that's?
One would expect such an
Yeah.
asterisk when they change the criteria, yes.
Right, okay.
Yes,
Thank
thank you.
you.
And I sure hope they include it. Okay, Representative Sellers.
Thank you. Since the bullet points were pointed out here, so you're looking to get rid of term limits, so someone could be appointed forever. And then also the chair, if I may, also, it seems like DHHS appoints the chair at that point instead of maybe technically the committee voting on it.
Thank you for that question. The term limits were removed from the committee. As you know, that we have a variety of specialists in maternal child health and folks that are on this committee to inform and process this work from a variety of different multidisciplinary areas. So we found by removing the term limits, we were able to keep those folks there without having them have to leave the committee. They're valuable resources. So if you have somebody who's the head of, let's say, maternal child health, and they've served for 3 years, and then they would no longer be able to be part of the committee. So it affords some flexibility for information and for subject matter experts to be on the committee. I'm sorry, what was the second part of your question about DHHS?
Appointing the chair.
Appointing the chair, yes. So we work closely with the members. We would have basically the committee is sort of administratively attached to the department. So we have some input on who would be the chair. I mean, it's a committee decision, but at the end of the day, it's sort of an administrative role that we would be taking on in that case. Thank you.
Okay, other questions? Okay, thank you for your testimony.
Thank you very much.
Is there anyone else who wishes to testify on Senate Bill 182? All right, seeing none, I will close the hearing. And the next hearing will start as scheduled at 11:15. I'm opening the hearing on Senate Bill 29, and I call Senator Rosenwald.
Thank you very much, Madam Chair. I'm pleased to introduce Senate Bill 29. For the record, I'm State Senator Cindy Rosenwald. I have the honor to represent District 13, which is most of Nashua. This bill implements several recommendations of the first annual Healthcare Workplace Safety Commission, which is attached to the Department of Labor. The commission was created through Senate Bill 459 in 2022 and represents a great deal of work by Senator Gray and former Senator Tom Sherman. And this was in response to an increase in healthcare workplace violence. All of our hospitals have been participating except Hampstead, and urgent care organizations were set to join the commission last summer. In the first annual report, it's noted that almost 3,000 incidents of violence were reported in our hospitals last fiscal year. Fortunately, most of them did not result in injury. However, there were 33 serious injuries. The recommendation from the first report that this bill seeks to implement are adding Hampstead Hospital to the commission. New Hampshire Hospital and Hampstead shall be required to report incidents just like all the other hospitals, and requiring monthly reporting of incidents to the Department of Labor. Finally, the bill clarifies that while the internal reporting to the Labor Department is confidential, the annual report with aggregate data is not confidential. This part's necessary because the Department of Labor issued the first annual report confidentially only to a few people. And I think it was just a misinterpretation of statute. So this will clarify that everybody gets to see the report, but nobody except the commission members themselves gets access to identified data. Our healthcare workforce is essential, and we have to do a better job to ensure they're not subject to violence. Better information is the right place to start, so I hope the committee will adopt this bill. Thank you.
Thank you. Yeah. Are there any questions? Representative Slushy? No? Anyone else? Representative Schmidt?
Thank you, Madam Chair. Thank you, Senator, for bringing this to us. So I recall the incident at the hospital in
Frisbee.
Manchester
Oh.
a couple of years ago, where that worker was terribly, seriously injured by a brutal attack by a patient. I'm wondering whether to your knowledge, the hospitals have undertaken steps to try to be more proactive in this regard, because a report after the fact is helpful, but we'd better stop the attack from happening. So what do you know about that?
So I don't know much about the internal workings of the commission, but I do know that all of the hospitals are very concerned about protecting their workers from violence, not only from patients, but from visitors and other staff members. New Hampshire Hospital has really has a really good protocol. I mean, there was that horrible incident with Officer Haas, but they have really taken proactive steps to train their staff in de-escalation. And the hospitals are working on it, but we need data.
Okay. Other questions? Seeing none, thank you, Senator.
Thank you very much.
Carleen Ferrier.
Good morning. Dear Chair and members of the committee, as a nurse for over 36 years, primarily caring for patients in various healthcare settings in the Granite State, I have experienced dozens of instances of workplace violence and hostile language. I'd like to share a personal story that I experienced a few months ago at my former place of employment. I had brought a patient in to be weighed and check their vital signs in preparation for seeing the physician. After I weighed the patient, as we walked down the hall, he said, "Now you better take 8 pounds off of that." And I didn't say anything while we were in the hallway. We went into the room and he said, "I told you to take 8 pounds off of that or my chart is not going to be correct." And I said, well, I can't put something in the chart that is not accurate and not what I saw on the scale. And he appeared visibly angry and starting to escalate. And I said, you know what? I'm not going to put anything in your chart. I'll let you discuss it with your doctor. He stood up, he brushed past me and walked into the hall and said, you know what? I'm not going to be seen today. And I thought, good riddance. But he turned around and came back and said, you're being a real pain in the A, and I am going to be seen. He sat down and I said, you've raised your voice to me. I'm calling security. And as I stepped out of the room with my eyes open, he made a very lewd gesture at me. So I left the room. I called security. I told them the situation. And one of the officers said, well, they always take several pounds off from my shoes when I go in. That's not the opinion I wanted to hear. I called him because I was afraid. So he said, all right, well, we'll stay here and we'll wait it out. So I went back into the little office that several of us share a cubicle in. And the other nurse, I told the other nurses about the story, and they saw the officers standing in the hall. And then a few minutes later, they said, they're gone. The officers aren't there anymore. So I went into the hall, and they weren't there. So I went back, I called security, and I said, I just called about this situation, and the officers left. And they said, oh, well, we got called to another incident. I said, well, that doesn't make me feel good. I don't feel safe. And you left the situation. It was not resolved. And he said, well, if you're not happy with that, you can call the supervisor. So I called the supervisor. The supervisor was the officer who argued with me about having weight taken off when he usually goes for his appointments. And he said, well, we asked around and they said the patient had left. So I just want you to know that in that situation, I felt very unsafe. I was afraid to walk to my car at the end of my shift. I thought about whether or not he would try to track me down. So that is a good example of the reality of healthcare. This continues to happen. It's workplace violence and hostile language is escalating. It's getting worse and worse. Senate Bill 29 is particularly important because it defines reporting requirements, eliminates exemptions from state-operated facilities, ensures that no person or facility shall retaliate in any manner against a reporting individual, and that the reports will not be kept confidential. We cannot solve this escalating problem if we do not understand the size and scope and potential causes. There are various research articles that you can find on workplace violence and its impact. I did share with you, I sent my testimony electronically to you so you have access to this particular article, which references that 25% of registered nurses report being physically assaulted by a patient or family member. while over 50% report exposure to verbal abuse or bullying. Nurses who are primarily responsible for providing life-saving care to patients are victimized at a significantly higher rate than other healthcare professionals. It's estimated that workplace violence causes 17.2% of nurses to leave their job every year. Nurses leave their job or avoid certain settings due to the risk of violence. This is unacceptable. As a nurse myself and the executive director of the New Hampshire Nurses Association, I represent over 1,250 nurses who are members. On behalf of my colleagues in the state, I want to thank the sponsors of this bill, as well as the sponsors of SB 459, who understand the seriousness of workplace violence and hostile language and the impact on the health and safety of the entire healthcare workforce in New Hampshire.
Thank you. Are there any questions? Representative Svitek.
Ms. Furrier, are you representing the New Hampshire Nurses Association in this?
Yes, I'm representing myself and the New Hampshire Nurses Association.
Thank you.
Okay. Representative Sachi.
Well, thank you for sharing your story with us, and thank you, Madam Chair. It's certainly a very compelling narrative, and please tell me it did not end there, because it sounds like you have some very substantial HR issues with security at your facility. It would break my heart to know that that was the end of the story.
That's the end of the story. I met with the head of the police and safety unit. I felt like he was yesing me. And he said, that he would take it under consideration, and it's not how he would have wanted it to be handled. But, when you look at somebody in the eye and you don't believe a word they're saying, that's how I felt.
Representative Sellers.
Thank you, Madam Chair. So I'm just trying to understand, how will this bill, if it passes, how will that affect you or workers? Will it help in any way? Can you tell me how it will help?
Absolutely. Something that's often said by an amazing quality improvement person, Dr. Deming, I don't know if anybody's ever heard of him. You can't define a problem if you don't have the data and understand what the problem is. And so this legislation really ensures that all facilities are tracking the incidents of both workplace violence and hostile language, the time, the setting, what happened around it, who was available. So we might begin to understand, the causes and what we can do beyond just de-escalation to address those problems. And so this bill, as I mentioned, is going to ensure that all of that data is collected. It's going to require that reports be sent to the Department of Labor, and that data will be analyzed, and you'll use the data to make data-driven decisions about how to address violence in the future.
Thank you. Representative Schmidt.
Thank you, Madam Chair. So I'm in my local hospital on a very frequent basis because they have excellent cafeteria food.
Oh, good.
So I'm there a lot, but I'm also at an age where I'm in the hospital, more often than I would have imagined, or that I want to be, except for the cafeteria. But your story horrified me at the idea. And my question is, what are the hospitals doing to train their nurses and personnel with regard to being ready or being having the best technique with regard to how to deactivate, defang, and so forth, so you recognize faster than you would otherwise?
Right. Nurses are trained in de-escalation techniques, and I would, I can't speak for all hospitals, but I would imagine that most of them are providing that training. But honestly, de-escalation doesn't always work. And in that situation, I did try to de-escalate the gentleman in several points in the interaction. He didn't want to be de-escalated. He wanted to threaten me. He wanted to make me feel uncomfortable. He wanted to feel powerful over me. And I had little recourse but to call for help.
Thank you.
Representative Slotchie?
I mean, was the individual at least trespassed from the property? Is there
No.
some fault? No.
No.
Anyone else? Thank you for your testimony.
Thank you.
Is there anyone else who wishes to testify on Senate Bill 29? All right, seeing none, I will close the hearing. And we will resume the executive session. Does someone have a motion on Senate Bill 29? Representative Long.
I move ought to pass.
Second.
All right. Do you wish to speak to your motion?
Yeah, I think this is a good bill. Passing it will help. If you have more data on what's going on, maybe new solutions to the problems of workplace violence.
Thank you, Representative Schmidt.
Thank you, Madam Chair. I would like to say that I obviously am in support of this bill, but as we know, the hospitals are required to treat everybody, right? You don't have to be able to pay. They're required to, if you walk in the emergency room, you're going to get treated, even if you've been there before and you never paid. I guess. I don't know about that, but I assume it's the case. They have to treat people who come in, which means that it's kind of like wearing a kick me sign to some degree, because there are people out there who are aggressive or whatever, and the witness was a subject of that kind of an incident. So I think we have to stay on top of this. Thank you.
Okay, Representative Slotchie.
Yeah, thank you. My only question on the bill is around the lack of confidentiality, and I have no idea what sort of issues that would open up in terms of privacy, and I have no basis to estimate how that might fall out. Does anybody else share my concern or have questions on that?
Well, the report is moved to not be confidential, but it definitely says it'll be aggregate data and will not have individual in the report. I believe the people on the commission are required to be to take any personal data they may receive as confidential.
Madam Chair,
Yes.
on the last page of the bill, on page 3 at the top, it does say that the data be kept confidential and they refer to RSA 151J:5. So they have that information as well.
Yes, and on page 2, line 26, it again references confidentiality provisions. So what is released to the public is only aggregate data. Okay, any Representative Sellers and then Leon?
Thank you, Madam Chair. Question I want to get clarity on is, you understand that the data is going to go to the Department of Labor and they're going to do analysis on it? That's what I heard, I thought. And do we have money for that? Should there be money appropriated for that?
We happen to have the Commissioner of Labor with us, so Commissioner, if you would answer that question.
Thank you, Madam Chair, and thank you for the question. I'm Ken Merrifield, Commissioner of the Department of Labor. The commission was moved from HHS to the Department of Labor in the last version of House Bill 2, and included in that was financial support for staffing. So we have an analyst who is working both with the commission and the data, and she won't be with me tomorrow at the commission meeting where I'm going to be presenting the data. But we have an excellent staff member who is doing that work now.
And this bill merely adding Hampstead Hospital and New Hampshire Hospital should not increase the workload significantly. I would hope.
No, in fact, both entities are participating voluntarily. But they were excluded in the original version of the bill, but they have asked to participate.
Excellent, thank you. Representative Leon?
Thank you, Madam Chair. I pulled up the confidentiality section that this references, and it seems quite solid.
Glad to hear.
And if I could add
Please.
about that, we received an opinion from the Attorney General that even the annual report was confidential. But I think that the commission would really appreciate being able to share the data that they're collecting, at least on an annual basis.
No, and it is explicitly defined as being aggregate data, which
Right,
is.
de-identified aggregate, sure.
Okay. Any other questions or comments? Thank you very much, Commissioner.
Absolutely, my pleasure.
All right. So the motion is ought to pass. Representative Sitek.
Since we're in executive session, I'll make an opinion here. It may complicate issues with your employer, but the fact is this is criminal activity. You don't need your hospital. If you're criminally threatened, you call the police, not security. But that, as I said, that may come up things at the hospital with your employer, but
Yes, and I would imagine that the security people at the hospital should be calling the police more often than they actually do.
okay, that would be the step.
Yeah. Like here, I mean, if we had an incident of violence, we'd call local security first and expect them to call the police if
Particularly
necessary.
during executive sessions.
Particularly then, yes, that's when tensions run high and we get all excited.
I mean, I just say, I know from my experience at my own hospital that the cops are there all the time for various different things, and it never hurts to talk with them and pass that information along. You don't have to make an official report sometimes, because believe me, the police want to involve themselves when they think there's a need.
Okay.
So,
Thank you for sharing your experience. Anyone else? Comments? Questions? All right, then the motion is ought to pass and the clerk can call the roll.
Vice Chairman Leon,
Yes.
the clerk votes yes. Representative Pierce,
Yes.
Representative Bailey,
Aye.
Representative Sheehan,
Yes.
Representative Sellers,
Yes.
Representative Slatchy,
Yes.
Representative Grota,
Yes.
Representative Schmidt,
yes.
Representative Davis,
Yes.
Representative Dargy,
Yes.
Representative Howard,
Yes.
Representative Long,
Yes.
and the chair,
Yes.
14-0.
All right. The motion passes 14-0. Any objection to consent? Okay, seeing none, we'll put it on consent. And Representative Long, at your earliest convenience. All right. So we don't want to do Senate Bill 182 until they get back to us on our questions. Representative Leon?
Thank you, Madam Chair. I'm still waiting on the amendment on 93. I don't know if we want to look at the 254 with the non-germane amendment.
Yes, and I think we should be able to cover that.
Perfect. Then I will move amendment 1548H to Senate Bill 254.
All right. Is there a second? Second by Representative Sellers. All right, do you wish to speak to your motion?
Thank you, Madam Chair. While we all wish we lived in a world where the FBI was a little bit more clear with their requirements, we don't live in that world. And therefore, I think it's important to give the Department of Education the language they need in order to make sure that they can have the right people providing care to children.
All right, Representative Sellers? Okay. Any other discussion, comments on the non-germane amendment? All right, seeing none, the motion is Amendment 1548H to House Senate Bill 254. Clerk can call the roll.
On the amendment, Representative Leon.
Yes.
Clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Sellers.
Yes.
Representative Slechy.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative Long.
Yes.
The chair.
Yes.
And that makes it 14-0
All right.
on the adoption of the amendment.
Representative Lamb?
I'll move ought to pass on Senate Bill 254 as amended by Amendment 2025-1548H.
It's with amendment.
With amendment. With amendment.
Got there first, Representative Schmidt. Is there a second? Representative Schmidt, will you second?
Happy to accept.
All right. Representative Land, you want to speak on it?
Thank you, Madam Chair. I think this is truly one of those housekeeping bills. So let's pass it and get it into law.
All right. Representative Schmidt? Do you have a comment?
No, let's do it.
Okay. Anyone else? All right. Thank you. The motion is ought to pass with amendment on Senate Bill 254, and the clerk can call the roll.
Representative Leon.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Sellers.
Yes.
Representative Slechy.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative Long.
Yes.
And the chair.
Yes.
The same 14-0.
Okay, motion passes 14-0. Is there any objection to consent? All right, seeing none, we'll put this one on consent also. All right. Okay, so today's Senate Bill 185 went to the licensing subcommittee, so we can't vote on that. Senate Bill 194, changing the requirements for cosmetologists. Does someone have a motion?
I'd move ought to pass.
All right. Is there a second?
Second.
Second, all right. Do you wish to speak to your motion?
Wait, can I ask a question? I mean, because we just had this discussion about this bill, and we like the premise of the bill and we like the concept, but I think it needs an amendment. So I'd like to work with Representative Leon on that so that we can.
Sorry, thank you. I don't think that it needs an amendment. I think that this bill makes sense, but I do think that getting some more clarification from the Department of Education that this won't negatively impact any of the CTEs. I've heard that and I feel relatively confident, but hearing back from the commissioner or a designee, I think would be helpful. So I guess perhaps I should pull this back just so
In
we
that
can
case, we
potentially
will-
have unanimous consent.
All right, so we have
So with-
questions on that one.
I'll withdraw my amendment. What's that? 194,
the
so I'll withdraw
cosmetologist?
my motion.
Okay. In that case, the only other one that is possible would be Senate Bill 285, the name change for PAs.
And I think we'd be ready for that. So
All right.
if you believe we're ready for that,
I
I will
do too.
move amendment 1623H for Senate Bill 285.
Okay. I don't believe we have that amendment.
I believe that was handed out
You got it
yesterday.
yesterday. It was presented yesterday by Representative Leon.
Oh, yes, there it is. Oh, yes, to the name change.
Yes.
Okay. All right, I see the amendment, 1623H.
Yes.
Is there a second?
I'll second.
Wait, I thought Long said.
Who said that?
Representative Howard said.
Oh,
Okay.
Howard.
Okay.
Leon Howard.
Okay, Representative Leon, if you'd like to speak to the motion.
Thank you, Madam Chair. This bill basically has a pretty large section, Section 1, where it changes the term physician assistant to a physician associate with a long list of all the occurrences of that in state law. It is amended in this amendment in order to remove two sections, D13, to remove 328-D13 because it needed further clarification. If you look at the sections 11 that is added to the bill at the bottom of the amendment, what that does is it makes it clear that somebody can't hold themselves out as a physician assistant, physician associate, or a PA, because in Oregon, where this has been done, there were some people, I believe, who tried to call themselves a physician assistant without the need for licensing because it no longer was a regulated term. So by changing the name for physician assistant to physician associate, we need to make sure that somebody can't lawfully call themselves a physician assistant with that change. So that's what this amendment does.
Okay, Representative Howard, do you have a comment?
Oh, I think that Representative Leon covered the subject quite thoroughly.
Okay, yeah. Protection for using the title is very common. And since this change allows employers to use the term physician assistant, we want to make sure that's covered as well as physician associate. And I support it. Any other questions, comments on the amendment? All right. Motion is to adopt Amendment 1623H, and the clerk can call the roll.
Vice Chair Leon,
Yes.
the clerk votes yes. Representative Pearson,
Yes.
Representative Bailey,
Aye.
Representative Sheehan,
Yes.
Representative Sellers.
Yes.
Representative Slotchie,
Yes.
Representative Groda,
Yes.
Representative Schmidt,
Aye.
Representative Davis,
Yes.
Representative Dargy,
Yes.
Representative Howard,
Yes.
Representative Long.
Yes.
It's not too late for aye. Chair.
Oh, aye.
There we are. Yeah, the ayes have it, that's true, 14-0.
All right, Representative Leon?
Oh, I'm sorry, I didn't see. I slipped out
Was
the
it
back.
before or after the question was called?
It was well before.
Well before.
But that's okay. I'd be a yes too.
All right,
All right, thank you.
in that case, 15-0.
All right, Representative Leon.
Thank you, Madam Chair. I move ought to pass on Senate Bill 285 with amendment to 2025-1623H. That was a
Okay.
1623.
Moved by Representative Leon, second by Representative Schmidt. Is there any comment or question? Representative Schmidt, do you wish to make a comment?
Well, the thing is, as somebody who experienced the PA about 16 years ago when I was having a coronary bypass operation, matter of fact, I had 4 bypasses, quadruple bypass, and the surgeon came in right after the procedure was over to check in on me and so forth. But from then on, I never saw him again. And the person who came in to attend to me was a PA. And he was completely competent. And I figured the surgeon who had a big reputation would not have this guy monkeying his business if he didn't know what he was doing. And in the meantime, I've had treatment by nurse practitioners and by PAs and so forth. And that's what they're called, PAs. Nobody calls them physician's assistants. And I think the questions that Representative Sellers was raising about, is it going to cause confusion and so forth, I think there's possibility that there would be some confusion initially, but if people realize that when the person comes in to attend to them, most people do anyway, that the hospital is on the hook for whether that person is properly qualified and investigated and so forth. So I think just like people talk about the CPA and they don't say certified public accountant, it becomes the jargon, and it's not like a dental assistant who is just handing instruments and not doing any of the dental work. So I think It's definitely a step in the right direction, and it will be accepted by the general population without too much question. Thank you.
Thank you. Representative Sitek.
I don't want to talk in terms of an amendment because I'd like to get things just done rather straightforwardly. But I heard a wonderful suggestion, and that's that when whoever walks into the room should identify themselves and their role, because I've been, like anybody my age, I've been to doctors quite a bit, and this one drifts in, this one drifts out. For all I know, he's housekeeping. I don't, and I'd like to. I think that's a pretty reasonable thing that the person identifies themselves and their role. For the
Representative Leon.
Thank you, Madam Chair. That is standard practice. I know that when I'm there and when I'm in my I'm just here to listen phase, I'm not always hearing when they identify themselves and their credentialing, but that is standard practice and something that is done, that when somebody goes in, they do identify themselves as a PA or a physician assistant.
Unfortunately, in most offices, even if they don't say they're a PA, they've got a handy name tag that says so.
Yeah.
Sorry.
The hospital, again, that I'm very familiar with, they wear a label. It doesn't just say what their name is. It says in very big letters, doctor or whatever they are. But they wear
it's the local office.
They wear the label because exactly that. The hospital wants you to know who they are and what they are.
Okay, Representative Leon.
Thank you. And also from the PAs, some of the information that they provided, they say that healthcare providers are all identified to require themselves by name and by their title. I'm assuming that that is true and that's the case. And if not, we need to make sure that that is, in fact, in the laws and rules instead of just a best practice if it's not being done.
Well, now I know I can harumph when I'm in the office.
Yes.
Representative Sitek, you are entitled to harumph anywhere at any time.
And Madam Chair, one more time.
One more time.
Sorry. And when I'm saying, and if that's so, I'm not trying to say that anybody's not giving us the information. I just try and only say, yes, I know this if I personally read the underlying thing with my own eyes. So I'm not trying to say that assuming that they're telling us the truth is suggesting that they aren't. So I just realized that my little catchphrase, I didn't want to have that misinterpreted.
Okay.
Well, that will save me from surreptitiously trying to look at their tags.
Yes, thank you. Any other comments, relevant or not? All right, seeing none, the motion is ought to pass with amendment on Senate Bill 285, and the clerk can call the roll.
Vice Chairman Leon.
Yes.
The clerk votes yes. Representative DeVries.
Yes.
Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Sellers.
Yes.
Representative Slotchie.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative Long.
Yes.
And the chair.
Yes.
15-0.
All right, the motion passes 15-0. Any objections to consent? All right, seeing none, we'll put that on consent. Thank you all. We will be back at 1 p.m. for 4 more bills. I hope that we will be able to vote on all of them, but if not, we won't. And thanks again. You feeling okay?
Me?
No, it's
Oh,
Pat.
oh.
He's got a nasty cough.
All
right.
Weird, because I've had a cough for 2.5 weeks and it's suddenly worse. So I don't know if it's the same
Yeah, for sure.
Good afternoon. Welcome back. I'm opening the hearing on Senate Bill 68, and I call Grant Bossy for Senator Lang.
Thank you, Madam Chair, members of the ED&A Committee. I am Grant Bossy from the New Hampshire Senate, here to introduce Senate Bill 68 on behalf of Senator Tim Lang, the bill's prime sponsor. The Governor's Commission on Disability currently has several ex officio members to ensure that it includes the perspectives of all the people it serves, including the DOE Bureau of Vocational Rehabilitation Supervisor of Blind Services. However, it does not include anyone representing deaf or hard of hearing Granite Staters. At the request of the Commission, Senator Lang introduced SB 68 to add the Deaf and Hard of Hearing Program Coordinator from DOE Vocational Rehab as an ex officio member as well. That's it. That's all the bill does. If you have any questions, I will make sure to get you an answer. Senator Lang, thanks you for your consideration and support of Senate Bill 68.
Okay. Does anyone have any questions? Representative Broda?
I'm sorry, you may have said it. So this is this bill at the request of someone?
Yes, the Commission itself asked to have this member added to it as a
Thank you.
non-voting ex officio member.
Representative Saito?
Is this a voting or non-voting member?
Non-voting.
Okay.
So it's similar to the other state officials that are on it, that are there for the meetings, but are not voting members.
Okay, because ex officio by itself doesn't mean non-voting.
Okay, there may be, I was told non-voting, that may not be the
Okay, no,
case, but yeah.
It's on line 4 of the bill.
Yeah.
Ex officio members without a vote on the commission.
Yeah.
So, no question about the quantity of them. It's easy to have lots of them. Any other questions? Seeing none, thank you, Mr. Bossy.
Thank you very much.
Is there anyone else who wishes to testify on Senate Bill 68? Please introduce yourself and give us a card after you've done.
Good afternoon, Chuck Sayer, Executive Director.
Turn the mic on.
Chuck
There.
Sayer, Executive Director, Governance Commission on Disability. Thank you for the opportunity. The bill, as written, the commission has no objection to it. It does add an ex officio non-voting member. We also have in the audience Director of Vocational Rehabilitation Services from New Hampshire Education Department, Mr. Richard Sala. The individual who will be added to the commission represents the interests of those who are deaf and hard of hearing, and there are other ex officio non-voting members. More than
Okay.
happy to entertain any questions.
Representative Groda?
Thank you. Do you know if anyone has actually contacted the coordinator regarding this position?
He's here.
So I do believe that would be Director Sala who could address that, but having spoken to Director Sala, I'm sure that he is aware of it, but I'm sure he's more than happy to also address this honorable committee.
Okay, thank you. Any other questions? Yes, do please introduce yourself. We would like some pink cards when you're finished talking to us.
Richard Sala, Director of Vocational Rehabilitation, and just to answer that question, the administrator from the for the deaf and hard of hearing program has been notified.
Thank you.
You're welcome.
Okay. Any other questions? All right, thank you, gentlemen.
Thank you.
Does anyone else wish to testify on Senate Bill 68? All right, seeing none, I will close the public hearing.
You remember he was before, Mr. Sala was before us a couple of years ago when we had a couple of bills on the commission.
Yes.
I think we would be ready, but I've been writing a lot of things, so I would hope that somebody else would have a motion handy.
Okay, Representative Sellers, you have a motion?
Oh, I was saying that we probably are ready for a motion, but I've been writing a lot of things, so I would rather not make it. And did I
Yes.
see Representative Heath raise his hand?
Yes, Representative Howard.
Sorry, Howard. I
I'll move
apologize.
OCP on SB 68.
All right, is there a second?
Second.
Representative Long, okay. Do you wish to speak to your motion?
I think that this is a common sense change that just adds a representative of the deaf and hard of hearing community, and this would be a beneficial change, allowing for adequate representation.
Thank you. Representative Long?
I don't have anything to add to Representative Howard's comments.
Anyone else have a comment, question? All right. Fortunately, it doesn't seem to increase the cost of the commission, except by a little of the time from the directors to attend the meetings. Anyone else? Comments? All right, the motion is ought to pass on Senate Bill 68, and the clerk can call the roll.
I still don't have the pink cards. Vice Chair Leon, please.
Yes.
Clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Sellers.
Yes.
Representative Slushy.
Yes.
Representative Grota.
Yes.
Representative Schmidt. Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative DeVries.
Yes.
Representative Long.
Yes.
And the chair.
Yes.
15-0.
All right. The motion passes 15-0. Any objections to consent? All right, seeing none, we'll put this on consent. Representative Howard, at your earliest convenience.
Madam Chair, I have a
Yes.
motion if you'd like me to proceed.
Yeah.
I can't take credit for this, but I thank Representative Leon for presenting this amendment, and I'd like to move Amendment 16. Oh, I've got all the copies in front of me.
Yes, we'll pass it around even as we speak.
It's 1646, and it is the comma issue that was, thank you,
Yes, section,
right?
Yes.
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 Exactly.
I'll second.
All right.
Who moved and seconded?
Moved by Representative Grota, seconded by Representative Leon.
Okay.
I move Amendment 1643.
Right, that's the
1646.
I mean 1646. Thank you.
Amendment 1646.
Yeah.
Which is still making its way down to Representative Pearson.
Yes, and it's for Senate Bill 93.
Right. And this also adjusts the effective date
Yes.
as requested.
Correct.
I'll also
Representative Land, do you have any other comments?
Yes, thank you, Madam Chair. OLS also noticed that there should be a hyphen between board and approved, so that's why that's changed too. But this should be pretty straightforward.
I see. The grammar nerds have struck again.
We raised the grammar signal, so they showed up.
Okay, very good. Anyone else have a comment, concern, question? Representative Reeves, is this more understandable?
This meets my criteria. Yes, thank you.
Good. Well, you were the one that raised the issue, and totally validly, I may add. So, all right. If no one else has a comment, the motion is to adopt Amendment 1646 to Senate Bill 93, and the clerk can call the roll.
Vice Chairman Land,
Yes.
clerk votes yes. Representative Pearson,
Yes.
Representative Bailey,
Aye.
Representative Sheehan,
Yes.
Representative Sellers.
Yes.
Representative Slotchie,
Yes.
Representative Grota,
Yet.
Representative Schmidt,
Yes.
Representative Davis,
Yes.
Representative Dargy,
Yes.
Representative Howard,
Yes.
Representative Reeves,
Yes.
Representative Long,
Yes.
and the chair,
Yes.
the same 15-0.
All right. And someone has a motion?
Yes, Madam Chair, I move ought to pass with amendment for Senate Bill 93.
Okay, is there a second?
Second.
Okay. Same as the amendment. Any comments?
No, I think the amendment, the discussion on the amendment covers this bill.
Okay. Representative Lamb?
No, I think it's all covered. It's a replace all.
Okay. Does anyone else have a comment, question, concern on the bill? Seeing none, the motion is ought to pass with amendment on Senate Bill 93. The clerk can call the roll.
Vice Chairman Leon,
Yes.
clerk votes yes. Representative Pearson,
Yes.
Representative Bailey,
Aye.
Representative Sheehan,
Yes.
Representative Sellers.
Yes.
Representative Slotchie,
Yes.
Representative Grota,
Yes.
Representative Schmidt,
Yes.
Representative Davis,
Yes.
Representative Dargy,
Yes.
Representative Howard,
Yes.
Representative DeVries,
Yes.
Representative Long,
Yes.
and the chair,
Yes.
15-0.
All right. Motion passes 15-0. Any objections to consent? All right. Seeing none, we'll put that on consent. And
We take it back up to cosmetologists.
yes, Representative Land has a motion.
Yes, thank you, Madam Chair. I move ought to pass on Senate Bill 194.
And I'll second.
All right. And you wish to speak to your motion?
Yes, thank you, Madam Chair, and thank you all for allowing me to contact the Department of Education for further clarity on the impact of this within the CTE programs for cosmetology. First, I want to share with you that all the directors of CTE programs for cosmetology in the state and all of the programs are in support of the bill and the change to 1,200 hours. Today, there are 3 full CTE cosmetology to licensure programs in the state, in Dover, Manchester, and Sugar River Valley in Newport. That's the one that's about to get up and running. There are additionally 2 that are out of state in Vermont, and we send students to their program. That is 1,000 hours. They won't change it because that's the standard in Vermont. And then there are what I sort of referred to as CTE Introduction to Cosmetology programs that have between 275 hours and 360 hours. Those are at older facilities that do not have salons. The 3 cosmetology to licensure programs do have salons that are available to the public, and that's sort of the differentiating factor about whether or not you're going to go as a full licensure. It would require renovations to Pinkerton, Concord like Concord High School or Nashua Hospital or the Cheshire Career Center in order to move up to this full program. And if that happens in the future, great, this will work for them. If not, doing this now deals with the issues of sending schools not having that full 1,500 hours. I don't really see them shortening the programs, but at least it makes it a little bit easier to hit that hour metric at the 1,200. So I think that this is a good bill. We've identified some things that might be on the nice to have list, but we'll worry about the nice to have list next year and go ahead and pass this just so that these students who are graduating out, if they're short 100 hours because of sending town issues, we're not going to make them go to another school that only takes 300 to 600 hours of transfer credits because these other schools, the Paul Mitchell, Empire, they don't take the entire hours that were offered by the schools as transfer credits. They only take a portion of it. So this is a great way to help out this year's graduating class. And I encourage you all to support the bill.
Okay. Representative Groda?
Thank you. My concern originally was that the CTE schools that didn't have the 1,200 hours would somehow be left out, but since they can go to another CTE school, I just want to make sure that the program is affordable for everyone. And I think that the bill does that, takes care of that. And my concerns for the other schools have been mitigated.
Thank you. Does anyone else have a comment? Representative Slotching?
Yeah, thank you, Madam Chair. I just wanted to make a note of how excellent the testimony was from the students and the instructors of the schools that we heard testimony from the other day. It was very convincing, and I'm looking forward to them having a very long and fruitful careers in the state of New Hampshire.
Thank you. Anyone else?
Yeah, they'll probably be in the legislature soon.
Not till they're over 18, so. Yeah. I'd like to mention that the opposition seemed to be concerned that the CTE graduates would not be expert hairdressers when they graduated, but nobody's an expert when they first graduate. The on-the-job training and the experience they gain by working is what turns them into experts. And this will let people start getting that experience and showing their expertise sooner, which is always a good thing. Anyone else? Representative Schmidt.
Thank you, Madam Chair. I think that especially the critique that was offered by the somewhat dramatic presentations of the opponents of the bill will lead the schools to emphasize and perhaps improve the hands-on aspect of the bill that the opponents reference as reasons for not going in this direction. They would be well advised to do so. So I'm hoping that they will learn from that critique.
Okay. Anyone else? All right. Thank you. The motion is ought to pass by Representative Leon, and the clerk can call the roll.
Vice Chairman Leon.
Yes.
The clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Sellers.
Yes.
Representative Slotching.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative Rees.
Yes.
Representative Long.
Yes.
The chair.
Yes.
15-0.
All right. The motion passes 15-0. Any objections to consent? All right. Seeing none, we'll put that one on consent. Wow. All right. I don't think there's anything else we're ready for. So we'll take a 10-minute break until 1:30 for the next bill. Good afternoon. Welcome back to ED&A. It being 1:30, I'm opening the hearing on Senate Bill 179, and I call Senator Gray.
Thank you, Madam Chair. My name is James Gray. I represent Senate District 6, which starts up in Alton and Gilmanton, comes down Route 11 to Rochester and Stratford. The bill in front of you today, the State Council on Housing Stability, I've been on that for quite a number of years now. And certainly housing, you know, as we all know, is one of those most important things that are going on. I don't always agree with all of their decisions, and sometimes I get outvoted, but it is a council that needs to continue, needs a little bit of support here and there. When this bill was brought to me, it was quite different than it is now. Certainly in the new way of doing things, we want to attach these things to a department so that they are the ones that are providing the support. So that's what you see in the top. There's a couple of changes in the makeup and who's active into the committee. You'll see down below. But pretty much this maintains the committee, makes sure that there is a department, that is overseeing them and making sure that they're providing the needed support. Certainly, when I first became a legislator, if we put it on there, all these committees and commissions would meet in this building, and there was complaints about, oh, gee, we got to do all this extra work and all of this. So that's back when we made the decision to attach them to various groups and have them be responsible. So if there's questions that I can ask, I'd be happy to do so.
All right. Are there any questions for the senator? Representative Grota.
Yes, could you please tell us how this bill, was this a request of someone, this bill, or is this
Yes,
something?
it was a request. Yeah.
By whom? Follow up by whom?
One of the members of the commission. Right?
Thank you.
I don't know whether they want me to say who or not, so, but it was a member of the committee.
So what does this Council on Housing Stability do, actually?
We have somebody that's going to come up after me that I think is much more capable of doing that. Between the different things that are out there and how we can do different things, they try to help coordinate. If you look at lines 16 through 21, okay, the Finance Authority, we've put into there, Health and Human Services, Business and Economic Affairs. All of those people have inputs into housing and how we can do it, how we can do the things right. And so all of those people are involved in this, and they write reports and tell us what we should do. And like I say, I'm not going to tell you that I agree with everything that they've put out, but I do go to the meetings. I do make sure that I show up and help them when I can to do the things that they need to do.
Person Howard, you had a question? No? Okay. Representative Schmidt.
Thank you, Madam Chair. So, Senator, you and I serve on the Assessing Standards Board together, and I have remarked on numerous occasions that you're a very, very faithful attender. So you know what's going on the Assessing Standards Board, and you reference the fact that you also attend the meetings of this particular finance authority. I noticed that one of the things that's done by this bill is repeal the requirement that the Housing Finance Authority submit a biennial housing plan. So presumably they have been doing one for the time that you've been on there, and
He's right over there, right behind me. Has already.
well, I wanted your comment, Senator. I want your comment on whether the plan that's been produced up to now has been of a quality that
It would be inappropriate for me as a member of the group to speak against the plan that was voted out of that group. And so I shall not do that.
well, I'm not asking you to speak against it, but we're getting rid of it. So what is your
And I think that the finance people will talk to you about that.
I'm hold you to your word. Thank you.
Thank you, sir.
Yes, Representative Rees.
Thank you very much. Senator Gray, I see that here added the New Hampshire Housing Finance Authority to the state council. One would assume that they're excited to be added. Oh, this is, okay, this
Look-
is the
look at
Finance
him.
Authority.
He's
I shouldn't
smiling.
have asked you. I wasn't
He's
sure
smiling,
what.
giving you a thumbs up.
That works for
He's
me.
been a very active member of the group.
Great. Thank you so much.
One final question, Senator.
Yes, ma'am.
Is this council absolutely necessary?
That's an interesting question because get the word absolutely in there, okay? And I believe it is necessary. I would not
Thank
be
you.
attending every month if I didn't think it was necessary.
Thank
But
you.
when you put the word absolutely in there, you know, that would cause me some hesitation.
All right, I will retract the word and accept your reassurances. Anyone else? Representative Howard?
Thank you, Madam Chair, and thank you, Senator, for taking my question. So on line 8, it adds 2 landlords to the council appointed by the governor. Would it make sense to potentially change that to a tenant representative?
Again, you know, that a lot of these people who don't have housing available, okay, would not be someone who would be able to have the means to go back and forth to these meetings on a volunteer basis. So, you know, for that reason, because of you know, if you do add somebody, which you can if you want, their availability, their ability to get to that meeting, even if they try to zoom into the meeting, would be so limited that I don't, and personally, I don't think it would be advantageous.
Okay, thank you.
That's also a extremely large committee with like 25 members.
Yes, ma'am.
And let's see if there's any of them qualify as,
Well, as you look through the list, you will see that there are advocacy groups that would protect the interest of the tenants and stuff.
right, there's the bureau chief of the Bureau of Housing Supports, behavioral health services, educational, there's already a landlord. This is just making it 2 landlords.
Yeah.
2 local providers of housing services, 2 of them. Regional Planning, Community Behavioral Health Association. It sounds like we got everybody in the world on that commission.
I'm not quite, but you know, since Representative Schmidt, you know, is so, you know, likes to be at meetings with me, you know, we could add him, you know, and
Well, there's 3 legislators.
that's right.
So,
right.
Representative Schmidt, if you're interested, we'll be glad to nominate you. All right, thank you very much, Senator.
No problem.
Rob DePiece?
Thank you.
Is this on? You can hear me?
Yes,
Yes.
thank
Okay.
you.
Thank you, Chairwoman McGuire and members of the committee. It's a privilege to be here before you. I appreciate your public service and giving me the opportunity to talk. I'm Rob Dappis. I'm the Executive Director of New Hampshire Housing, also known as New Hampshire Housing Finance Authority. And so we've been members of the Council on Housing Stability since it was established initially by executive order in 2020 and then sort of passed into law in 2022. And we support this bill. For those who aren't familiar with New Hampshire Housing, we're an independent self-supporting corporation created by state law. And so we have a mission to support and promote Housing Solutions for the People of New Hampshire. We run a couple of different programs. We're the housing authority that runs the Section 8 or Housing Choice Voucher program for areas of the state that don't have a local housing authority. We do a whole bunch of first-time homebuyer programs through participating banks and mortgage companies around the state. And then we run multifamily financing programs, in some cases administering federal or state resources or below market debt to help nonprofit and for-profit developers around the state create affordable rental housing. And so I'd be happy to answer questions and talk about the work of the council. It's been a privilege to serve on it and to help support Katie Easterly Marte from the Community Development Finance Authority, and initially Chris Santinello, who I think is an assistant commissioner at DHHS, and now it's transitioned to Deputy Commissioner Tricia Tilley, who have really shown strong leadership. New Hampshire Housing administers a lot of the state housing programs, and so it seems to make sense that New Hampshire Housing would be added to that list of sort of co-lead agencies. And we have great relationships with our partner agencies and would look forward to working with them on jointly sort of leading the council. I want to address a specific question that came up, Representative Schmidt, about the biennial housing plan. Right now that's written into our statute. And that was, I think, a vestige of a time when there was no state council on housing stability. That this council is really like the only body that's charged with sort of coordinating and leading state housing policy. And before that, there wasn't a group like that. You know, New Hampshire Housing sort of was the default at times, but we don't administer the homelessness programs that DHHS does. There are community development programs that touch on housing, which CDFA runs. And obviously there's the private sector is essential and provides most of the housing that people at any income level live in New Hampshire. And so before there was a Council on Housing Stability, I think it made sense maybe for New Hampshire Housing to write a biennial housing plan every other year saying, these are the efforts that are underway to address housing issues in the state. And we have been doing it faithfully, and I've got a copy of our last one. If anybody, I only have one hard copy, but I can send the link around if people would like to see that. It just seems duplicative now that we've got a Council on Housing Stability. It's almost exactly the same content, and we're doing an annual report as the council, which talks about all the ongoing efforts to address housing issues in the state. So we proposed striking that language. Again, just sort of seems duplicative. And I would say the same thing about the added reference to work groups. There are a couple of different working groups around the state that do things like pull together the federal application for various funds. And it just seems to make sense that if there's one body that's created in state law to coordinate and lead on state housing policy, that group should be sort of the nerve center for all those policy conversations. And this gives us sort of a clearer ability to do that. So I hope that's helpful. I'm happy to talk more about the work that we do, but maybe I'll just pause and see if there are any questions.
Representative Bailey?
Perhaps a simple question. It says in here that they'll be attached administratively to HHS. Are they freestanding now, or?
Yeah, and Senator Gray said that's something that needs to be done. I mean, HHS has been providing some administrative support, and we've been sort of making it work. We got a little bit of support from the Charitable Foundation initially to have somebody who could sort of manage the administrative duties, but they're not administratively attached to any agency right now.
Thank you.
Yes.
Yes, other questions? Okay, thank you very much.
Thank you.
Is there anyone else who wishes to testify on Senate Bill 179? Seeing none, I'll close the hearing. Certainly reasonable.
No, Dapis. D-A-P-I-C-E. Dapis.
All right. Okay, committee. Representative Grota has a motion. Yes, going into executive session.
So, Madam Chair, I move auto pass on Senate Bill 179.
Does someone have a second?
Second.
Second by Representative Long. Did you wish to speak to your motion?
Yes. Upon review of the size of the council, it's rather large. And Trish Chili, who was a member of DHHS, is on that board. So it makes sense to me that they would be affiliated with DHHS. And I think that it's important to have that kind of continuity between agency and council on this issue.
Thank you. Representative Long?
Yep, I agree. I think housing stability obviously is an important issue. Definitely a big issue in Manchester. And a lot of it really is, in some sense, a health and human services issue. So it makes sense that to have a closer connection to the agencies that are dealing with the problems people have that can contribute to housing instability.
Okay. Anyone else have a comment? I'd like to say I'm glad we're getting rid of one duplicative report that no one will read and will just gather dust. Anyone else? All right, the motion is ought to pass, and the clerk can call the roll.
Vice Chairman Leon.
She's not here right now.
Oops, yeah, so it is. The clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Sellers.
Yes.
Representative Slutchy.
Yes.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative Teveries.
Yes.
Representative Long.
Yes.
Chair.
Yes.
14-0. 14-0.
All right, motion passes 14-0. Any objection to consent? Seeing none, we'll go for consent. And, all right, and the committee is in recess until 2 p.m. right, having reached 2 o'clock, I open the hearing on Senate Bill 192 and call Grant Bossy.
Good afternoon, Madam Chair, members of the committee. Grant Bossy, Deputy Chief of Staff of the New Hampshire Senate, here to introduce Senate Bill 192 on short notice on behalf of Senator Darrell Abbas. His committee is running a little long. He appreciates the courtesy. This bill would establish a study committee to study enhanced coordination between county correctional facilities, the Department of Corrections, and the Department of Health and Human Services. Specifically, the committee would be charged with studying implementation of a justice system unique identification number to better understand and track the trends of high utilizers. Development of a unified offender information system to be used by county jails, the Department of Corrections, the Parole Board, probation and parole services, including flags for behavioral health, treatment outcomes, and recidivism, and also the creation of data dashboards to respond to trends in real time. And I'm sorry, Representative Sitek, these were not on the prepared remarks. He gave me some extra data just before I started. He was approached by folks at the Council of State Governments Justice Center, which have been partnering with New Hampshire agencies over the last few years to address the high and persistent use of public health and criminal justice resources by people with mental illnesses and substance abuse disorders. CSG conducted an extensive qualitative assessment and analysis of case-level data from the Department of Corrections, as well as Medicaid claims data from DHHS. As a result of their findings, we need to prioritize reducing the reliance on incarceration for people with SUD and mental health challenges. By prioritizing this, we can decrease recidivism and its associated costs and improve public health and safety. In their analysis, CSG found that there's a small number of people cycling through jails and prisons in New Hampshire, often for lower level offenses and supervision violations and revocations. While parole revocation rates are low, they are also driving state prison admissions. People who are high utilizers of jails and prisons, which is defined by individuals with 4 or more county jail entrances between FY 19 and 21, or 3 or more state prison admissions between 2014 and 2023, have more complex and more frequent behavioral health-related encounters than non-high utilizers, particularly for the female population, and they both rely heavily on Medicaid for healthcare access. One Department of Corrections and Department of Health and Human Services have done a good job of coordinating with each other to improve services and outcomes for incarcerated individuals. By streamlining and enhancing their ability to communicate across systems, the better our state will be to respond to the needs of these populations, particularly as they re-enter the community. I'd be happy to defer questions and get you answers if you have any, and I appreciate your time and consideration for SB 192. Thank you.
I have a question. I don't
Yes.
know. This reads like you've already decided what you want the study committee to do. You've defined the system you want them to study. So I don't understand why you need a committee.
Senator Abbas didn't think this was quite ready as a bill, and he thought that bringing together a senator and some reps and the stakeholders could hammer out what this would actually look like, protecting privacy, working with different systems across the agencies. He thought that this work could be hammered out over the summer and come in with a clean bill in the winter.
Thank you. Representative Broda?
Thank you. So would it not be possible for this to happen over the summer without this bill? I mean, they could meet and decide for themselves what it should look like before they submit their clean version.
That would be possible?
Yep.
So,
Okay. Any other questions? Thank you very much, Mr. Bossick.
thank you.
Representative Sitek.
I might just say on my sabbatical on criminal justice last term, this was a really big issue. I don't know whether you've done any coordination with them, but the idea of people going to county corrections that have mental health issues, not criminal justice issues, it was a hot topic. Criminal justice would be very interested in this bill or this concept.
I'll share that with the senator. Thank you.
Representative Schmidt.
Thank you, Madam Chairman. Following on my colleagues' earlier questions and remarks, just to point out, in Stratford County, we have a mental health court. I've been on this committee for 18 years now, and we have been talking about this type of thing and analogous phenomena and so forth with regard to co-occurring disorders and so forth. Seems to me like this is there is so much evidence out here and out there and so forth that this it seems like it's we know enough already to start putting together something or having so. I have the same feeling that we kind of know all these things already. Why ain't we doing anything about it?
Thank you. Anyone else? Thank you, Mr. Bossy.
Thank you.
Aaron Thorvaldson.
All right. For the record, Erin Thorvaldson with the Council of State Government Justice Center, here in support of Senate Bill 192. There's a couple handouts that are coming around. One handout is some summary of the work that was just covered, but some additional context there, as well as a handout around a 50-state public safety report that we put out that looks at the state ID number and what other states have done across the nation, and then a bit more context around data sharing and information sharing. So those will be coming around shortly. But I want to thank you for the opportunity to provide testimony in support of Senate Bill 192. As I said, I'm with the Council of State Government Justice Center. We are a national nonprofit, nonpartisan organization. And since 2021, we have been working in close partnership with the state of New Hampshire under the Justice Reinvestment Initiative to advance data-informed criminal justice strategies. Our focus in New Hampshire has been on reducing unnecessary system involvement, improving behavioral health outcomes, and helping the state maximize the impact of its public safety investments. SB 192 will create a study commission to provide recommendations for increased communication and data sharing across DOC, DHHS, and county jails. It is an exciting and important bill to move New Hampshire forward by creating recommendations for a cross-justice system identification number, a unified client information system, and real-time data dashboards. The bill will create the foundation for more efficient and cost-effective cross-agency collaboration. It supports New Hampshire's commitment to local control and data-informed governance while offering a path to meaningful cost savings by reducing redundant spending, improving service coordination, and focusing limited resources on individuals with the greatest needs. As referenced earlier, through our work with Justice Reinvestment, we found New Hampshire has a small population of individuals who cycle between the county jail system, prison, or both. They only account for about 8% of those in the criminal justice system, but are responsible for a disproportionate share of spending, costing the state approximately $123 million in incarceration expenses over a 3-year period. Our analysis showed that these individuals repeatedly cycle through jails and prisons, not usually for new criminal conduct, but due to supervision violations, such as missed appointments or substance use. Such individuals cost $13.1 million for parole revocations alone, compared to $11.6 million for others involved in the system. These costly outcomes are largely preventable and often stem from fragmented oversight, delayed or missed responses to behaviors, and disconnected information sharing across agencies. Agencies are often forced to make operational and policy decisions based on outdated or incomplete information, sometimes relying on data or reports that are a year or more older. Real-time data dashboards will give state and local officials the ability to monitor supervision compliance and respond to trends in real time. Further, a unified state ID number will equip decision makers like yourselves, as well as state and agency leadership, to better monitor and understand who is moving through your systems and why, and crucially, what might prevent them from continuing to cycle through county jails and prisons. Without these tools, New Hampshire continues to operate in the dark, using yesterday's data to make decisions about today's problems. As the study committee undertakes its work, it will be essential to center individual privacy and data protections in all discussions and recommendations. Existing federal and state laws such as HIPAA, 42 CFR Part 2, and New Hampshire's Data Privacy Act, which took effect earlier this year, provides strong safeguards to ensure that any data sharing is lawful, limited in scope, and aligned with individual consent. These laws are designed to prevent the misuse of sensitive health and treatment information, reinforce accountability, and uphold public trust. Many agencies in New Hampshire are already sharing information lawfully through mechanisms such as business associate agreements under HIPAA, qualified service organization agreements under 42 CFR Part 2, and standardized consent protocols. Protecting personal data is not only a legal requirement, but a foundational principle for any cross-system collaboration. We'd be glad to provide additional information on how these protections can guide further implementation with our written testimony. SB 192 does not create new mandates. It strengthens existing efforts. It provides the infrastructure to improve agency coordination, streamline service enrollment under the 1115 Medicaid reentry waiver, and measure outcomes through data dashboards and reporting. Further, SB 192 supports DOC's data modernization goals, helping ensure that current investments deliver lasting impacts. We are grateful for the opportunity to provide background and information in support of SB 192. We view it as an important opportunity for New Hampshire to uphold individual privacy while advancing data-informed approaches to addressing complex behavioral health needs and public safety challenges. I want to thank you for your time and consideration, and I would be more than happy to answer any questions.
Thank you. Representative Schmidt has a question.
So this sounds like the result of the bill that we're processing at the moment. I recall years ago the teachers used to say, the elementary school teachers would tell you which kids were going to do well and be the doctors and lawyers and leading business people. And they could also tell you which people are going to wind up in jail. And you've given us an astonishing, almost a litany of aspects of this situation. And I'm going like, why haven't these people already been talking with one another? I mean, you say certain data must be held confidential and so forth, but we certainly know the people. It's in the newspaper. You can see so-and-so was in front of such and such a court and got found guilty of X and so forth. I can't give you the specifics because I don't read that particular newspaper on a regular basis anymore. But I mean, what are all these entities doing? Each one has a part of the puzzle, and it seems like they all ought to sit together and put the pieces together. Because you've given us if this were the report of the study committee, we'd go like, very good, let's do something about it.
Yeah, and I mean, within our analysis, we worked with stakeholders from DOC, DHHS, county jails, community-based providers, and what we found is that these systems are very siloed. And so when individuals are moving through, county jails to state prison upon being released, and potentially, I think many had mentioned earlier, some of those co-occurring disorders, now they're involved in the behavioral health system. These systems are not talking to one another. And so we're often seeing that there's redundant services happening. There's an extreme cost, as I mentioned in my testimony, because we have duplicative services. We don't know what type of treatment or programming individuals are getting in prison, or what type of services, physical or mental health services, that they're receiving. And so that's why we had worked with Senator Abbas on this for a study commission to really start solving some of these issues and breaking down some of those silos across agencies so it can be more streamlined and more efficient.
Follow up. Thank you. So New Hampshire is composed of 10 counties. These 10 counties all have county houses of correction. Notice we don't call them jails, we call them houses of correction. That's what it's supposed to be all about, right?
It depends on which county you're in,
Well,
Representative.
I'm sorry, my county calls it a house of correction. I don't know about other counties, but I thought they all did the same thing. But the bottom line is that we have authorities at the county level. It just seems all you folks in the silos that are not talking to each other, guess what? Start talking to one another. So
That's okay. Anyone else? Representative Saitek?
Is this problem really solvable? Here's what I mean. So they're using the jail and the prison, bouncing back and forth because of primarily mental health issues. Those issues aren't going to go away. We got to put them, society wants to put them somewhere, help them or help themselves. What CSG, what's your solution, CSG? Do you have something to suggest?
Yeah, that's a great question. And as I mentioned in our analysis, what we were finding, again, those silos, but the state ID number is one, and this is one handout that I did share with you that many states have gone to, is having this shared unique state ID number can help share information across agencies. And so we know that by typing in that state ID number that this person has previous experience with DHHS or behavioral health issues, has previous experience in prisons, could be housed previously in a county jail or house of corrections. And so having that state ID number would then allow that more efficient sharing of information. So then we can really start targeting the needs that we've identified through different assessments and through their experience in the jails and through state prisons to really start targeting the things that are driving them to commit criminal behavior.
Representative Slytek has a question.
Thank you. What percentage of these frequent flyers are drug related?
I don't have that stat in front of me, but I can get that to you in follow up.
Because where I'm going is I think they don't need jail. They need a
Treatment.
solution that we don't have yet.
Right. And hopefully, having more streamlined systems that can be better achieved.
Representative Howard.
Thank you, Madam Chair, and thank you for taking my question.
Of course.
I have some concerns about potential privacy issues because I know that in your testimony you said, they're going to be covered by various laws like HIPAA that would prevent any of those breaches. But this is just a study committee, so I'm a little bit confused as to how an individual identification number that goes to somebody and is tied to that person would not be a breach of their privacy. So what are your thoughts on trying to separate that from, the current situation where we're looking at a situation where we have something identifying somebody versus the actual privacy laws and constitutional statutes that we have here in New Hampshire?
Yeah, that's a great question. What other states have done to help combat that issue are releases of information. And so that's often a way that allows the individual to have a bit more control about what's released to certain agencies. Those that are on supervision can work with their probation agent and say, yes, I am consenting to releasing this information about my treatment or my behavioral health needs to X, Y, and Z, treatment provider. So that's one way that individuals can help take a bit more control over what is shared and what isn't. Of course.
Representative DeVries and then Slouchy.
Thanks. I also have a privacy concern. The way that this is written in this, and I missed a couple of minutes at the beginning. So,
Sure, no problem.
So this may have been covered, and I apologize if it's redundant. This is written to study the implementation of a justice system unique identification number. Has it been concluded that I understand what you're saying, that it allows the system to track as Representative Slytek called it, frequent flyers. But have we concluded that necessarily this is a good idea? Because it seems like this is the conclusion. Now go do the work on this. I'm not sure that we've come to that conclusion yet, but perhaps we have, and I just missed that.
Sure. So I can make sure to include at least our full analysis that does cover some of the issues that we found with individuals getting lost in the system. Something that Senator Abbas had shared with his experience when we were in the Senate was he had a client that they were in front of the judge up for revocation, and they didn't actually know what was going on with him, where he had been, what type of treatment he had gotten, what type of services, and they were planning on revoking him for treatment noncompliance, essentially. And it came out that really, because there wasn't shared about what treatment he was in or what was required by the court for treatment, that that was something that shouldn't be happening, and stepped forward and ended up saying that if this information would have been shared, we wouldn't be here in court. We wouldn't be, talking, about this today. So having a state ID number is something that each agency could be running and then saying, okay, here's the rules of supervision that this person is on. Here are some of the treatment options, again, with some of the release of information, as I mentioned, and the different protections that are there. So I understand the concern about did we get here or are we there yet? And I think some of our analysis I can share with you at a later time would show that.
Follow up.
Thank you, Madam Chair. So that sounds to me, but again, this may be a misunderstanding on point on my part. That sounds to me like certain individuals have concluded, and perhaps your organization as well has concluded, that there should be a unique identification number, as opposed to we have come to the conclusion as a state government that there should be a unique identification number. So my concern about this is that this presumes a certain result and conclusion that hasn't actually been made yet. And I may be, but I'm not sure that a unique, I understand the arguments in favor of it, efficiency, better, faster intervention, all of those things. I think the way that this is written right now reads to me like, oh yeah, we're going to have a unique identification number. And I don't think that we've answered that question fully yet, or at least I don't think that it could be my ignorance. Thank you. So if I am wrong, I guess that was a question. Please tell me if I'm wrong.
Right. So as part of our recommendations from our analysis, like I said, we've been working here since 2021, was based off of best practice, based off of what other states have done, what we know has been working in other states as far as being more streamlined and more efficient services. We did make the recommendation that New Hampshire adopt a unique state ID number for individuals. So that was part of our recommendations.
Thank you. Follow up.
But has that, I guess my question is, I make recommendations all the time. People frequently do not act upon them. Has there been any entity that says, yes, this is that's your conclusion, but yes, this is the conclusion that the state has as well, besides it being represented in this piece of legislation?
Yeah, I think that would be the intent of the study commission, that they could look further into the issue and then make a recommendation, yes, no, should we adopt this?
Representative Slotchie?
Yes, thank you, Madam Chair, and thanks for taking my question. I assume that these people who have been referred to as frequent flyers or the most costly high utilizers, thank you very much. They have names, they have social security numbers, they have other identifying factors. And so I find myself curious as to why this identifying number is going to be more useful and unlock a better sequence of outcomes than what's available through their current set of identifying factors.
Yeah, I can speak to what other states have done, and a social security number is usually not shared as something that would be in like a DOC system or a county jail system or across behavioral health systems. And so that state ID number would, in my opinion, protect some of that information, protect your social security number. You're not using that. It's not being, reported out to certain entities and different agencies, but it's a unique state ID number that would be tied to DOC, county jails, DHHS.
Anyone else? Representative Saitek.
This is a better question for the sponsor, but I'll try to snare you with it. And that's, we have in state government an interbranch council for criminal and juvenile justice. And that's a voice we haven't heard from. It would seem that they would be a relevant testimony here. Do you know anything about them, or is that here in New Hampshire?
Yes. So we've, like I said, been working here since 21. I transitioned onto the project in July of 2024. And so our previous team met with multiple different stakeholders, different agencies, councils, like I said, state agencies, community-based providers, treatment providers. And so I would have to check if they met with that council as well, and I can get back to you on that. But we did, our previous teams before I transitioned on, did work with a multiple set of stakeholders.
Thank you. Other questions? Representative Schmidt?
Thank you. We have another committee in the House, as you probably know, it's called Criminal Justice. And it seems like, what?
And public protection.
Well, we call it
Continue,
just Criminal
Representative
Justice,
Schmidt.
who are not, we can't remember all the committee names anyway, when you get even our name, executive departments and administration, we'd be halfway through the day if we called our name out loud, we call it EDA. But the point is, it just seems like it's all here and all the puzzle pieces exist. Why aren't the entities put them together? And in your handouts, they scream out loud, here's what's being done already. So,
Thank you, Representative Schmidt. Any other questions? All right, thank you for your testimony.
All right, thank you.
Is there anyone else who wishes to testify on Senate Bill 192? Seeing none, I'll close the public hearing. Representative Schmidt, do you have a motion?
well, I'm not sure whether it should be ITL or whether it should be ought to pass, because clearly this state has a hell of a problem, but according to the handout information, so do all these other states. It's
Well,
out there.
I'll second your motion for ITL. So we can discuss it on that
I
basis.
won't feel bad if it gets voted down, because maybe this is the final right step to do, but maybe not. If I don't get a second, I won't feel bad.
We have lots of seconds, including me, Representative McGuire, Representative
Representative
Schlosky.
Schlosky, yes.
You pick one.
I love all of you.
Okay, we'll manage. Okay. Representative
If you
Schlosky.
don't mind, I just don't understand how some magic identifying number is going to fix any problems, and I don't think I heard an answer to that question when asked. So it's a number that isn't a social security number that can identify somebody, but so is a name, so is everything else.
Yeah. Representative Broda, you have a comment?
Well, I'm disturbed to think that something we can't do ourselves over the course of the summer with right people talking to each other can be achieved without legislation. I don't think we need this. I think we can do it on our own, and I'm not even sure it's necessary, because I think there are different ways. If the agencies are not talking to each other, shame on them. And maybe that's what we
Bullseye.
should be focusing on instead of this method.
And Representative Howard?
Thank you, Madam Chair. I have, as I said during and what my question was directed towards the representative from CSG. Privacy is not necessarily guaranteed in this, or I should say privacy rights aren't necessarily guaranteed in this legislation, because we're just looking at a study committee. And I think that's the biggest thing that this type of legislation hinges on, is whether or not we are supporting and not infringing on people's constitutional rights to privacy. So, I mean, with that, this is just, without that kind of guidance, I don't think that I could support any sort of legislation like this.
Representative Reeves?
The issue that I have with this is it presumes a certain outcome, and it doesn't answer the question of whether we should do this. If this were a question of if we should, or the committee were about deciding whether or not we should have a number and what the potential abuse of a central number might be, an identification number, that would be a different story to me altogether. But the way that this is written, it presumes the purpose, or it says the purpose of this group will be to come up with a plan forward to implement that. And I don't think that question has been satisfactorily answered, or at least I haven't seen it in the record.
Yeah, I would agree with you entirely. This presumes the answer, and you don't need a study committee if you know what the answer is. If Senator Abbas needs help in designing his bill, he's more than welcome to invite anybody from the House or any of these departments to talk to him. I don't like the idea. Representative Sysak?
Did we ever go into executive session?
Yes.
Okay, great. Okay.
We did. We were I was with you on that.
Yes, okay.
I mean,
So
but-
is there any further comments?
I'd like to make the comment that maybe based on a hangover from my previous 2 years in criminal justice and public protection, that there was a real need for better coordination, and I'd like more work done on this. So,
Okay. Representative Schmidt and Long?
well, if people think it's worth doing something during the summer and we want to retain the bill and put it all together, all the stuff they've handed out, whatever. But I mean, when you step outside societal norms and commit crimes, you get something called and you get convicted for it. You get what's called a record. And the testimony said that the same small group of people are costing millions of dollars in this state alone. This screams out for start talking to one another and do something about it. In Stratford County, we have a mental health court because these people have very often co-occurring disorders. I heard that 13, 15 years ago on this committee. Co-occurring disorders, some substance abuse, and very often they are trying to self-medicate for a problem that they have in a dysfunctional family very often.
Okay.
And it's the same group of people. Like I said, the teachers know after second or third grade which people are going to wind up in jail.
Representative Long?
Yeah, so I don't know if coming up with a unique ID number is the solution here, but I do agree with the need for better coordination between these agencies. So I would be voting against ITL. I think it makes more sense to amend it to have a more neutral language about what the commission's or the committee's goal to study is, and make it something more like solving coordination problems between these agencies, and they can make whatever recommendation makes sense when they study the problem.
Representative Pearson?
Thank you, Madam Chair. Based on the handouts, it seems to me the question is more along the lines of do we participate in something that exists than trying to come up with a commission to invent something similar to what already exists. That if we have 18 states doing this and 20 states doing this and a lot of other dots in another page, 33 states doing this, it just seems like it's a matter of participation than it is invention. So I think that's really the question here, not creating a commission to invent something that already exists.
Yeah, and I would agree that if we wanted to study why they aren't talking to each other, that's a totally different problem. But I don't think this particular study committee would do very much good. Anyone else? All right. The motion is ITL by Representative Schmidt, and the clerk can call the roll.
Vice Chairman Leon.
Why she just got here is unfair.
I think she was here when the question.
She was here when the question was put.
Okay.
What is the motion?
ITL.
Okay. I think yes.
Clerk votes no. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Sellers.
Yes.
Representative Slutchy.
Yes.
Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative DeVries.
Yes.
My last chance for an ally. Representative Long.
No.
Hey, yippee. And the chair.
Yes.
That, what do we have here? 15 says 13-2.
Okay, the motion passes 13-2. Do either of you plan to write a minority report? Representative Long? No. Okay, no minority report. Do you object to consent?
No.
I don't.
Okay, we'll
No,
put that
not
on
gonna delay
consent.
things.
Thank you, that was a very troublingly written bill. All right, back to our other business. I'm going to open the public hearing on Senate Bill 190, and I call Senator Prentice.
Good afternoon, Chair McGuire and members of House Executive Departments and Administration. Boy, it's been, well, probably about a year since I've been here, so nice to see you all. I'm here to introduce Senate Bill 190. Senate Bill 190 is intended to change the quorum requirements on two legislatively established bodies or legislatively established commissions. So one is we call the SHAWSHIP, which is the State Health Advisory and State Improvement Plan Advisory Council, and the other is the Council for Interdisciplinary Workforce. So let me say just a few things, especially about the SHAWSHIP, is that it charts the course for healthcare priorities in working with healthcare entities throughout the state based at the Department of Health and Human Services. The interdisciplinary workforce manages the workforce related issues of all of these different disciplines as they're working around not just access, but systems of care in our state. As you can see, these bodies are both large. So SHAWSHIP, or the State Health Advisory, it's just such a long name. It's like a tongue twister. It's a long day. State Health Assessment and State Health Improvement Plan, they have 39 members. And the Interdisciplinary Primary Care Workforce has 23 members. And so what's become unmanageable is being able to have a quorum in order to hold meetings. So here is what I am suggesting in this proposed legislation is changing the quorum requirements to a majority, which will allow for, well, not just allow for, but still requires compliance with 91A. So that you have to have a quorum, a physical quorum in the room. You have to comply with 91A. If there's anybody remotely attending the meetings, everything has to be done in a synchronized manner, and all votes are roll call votes. So we are in compliance there. So we would be looking at the interdisciplinary workforce having, SHAWSHIP having 6 people in the room, which is 1/7, and the interdisciplinary primary care workforce in moving down to, isn't it interesting, 3.2. So I'm saying 4 people most likely in the room for these meetings. These bodies want to continue to do their job. They're just not able to because their membership is so large, and getting a physical quorum in the room has become a barrier to doing their job. That's why I was asked to bring this forward. And that is what I help. So that is my introductory testimony. I'm happy to take any questions. And I also have a representative from the Department of Health and Human Services here to manage any of the issues or technical issues that I cannot. Thank you.
Thank you, Senator. Are there any questions? Representative Svitek.
Can they meet remote? Can a member participate by Zoom?
As long as there's a physical quorum in the room that meets the language,
The
they can,
physical quorum must be in the room.
correct.
Oh, okay, all right.
It's
Thank
just
you.
that this defines a physical quorum as less than half. It's only 1/7, which is an
1/7.
odd number.
I know. I actually thanks for AI and Google to figure these things out. But yes, it is an odd number, but That's who's in the room, and then others can participate remotely. And again, they have to comply with all the provisions in 91A.
Representative Lamb?
Thank you, Madam Chair. I think, and thank you very much, Senator, for bringing this forward. I really appreciate this. Looking at these in combination, the 1/7 in attendance and the ability of the majority of the appointed members of the council, I'm worried that that 1/7 could, in some scenarios we've seen in other councils, be one person, because there have been challenges with appointing people. I know that the Shawship is a pretty important council, but I'm just very concerned that having one and the other together could impact the effectiveness of this council if in the future it's harder to get people appointed to it.
So I did miss, so thank you, Representative Leon, for your question. I did miss part of that, but I think to help out
Do you want me to
here-
clarify?
Yeah, sorry, I missed
Okay.
part of it. I think to clarify though, I've defined the number of people that have to be in the room, so it wouldn't just be one person.
Yes, thank you. You clarified the number that need to be there as 1/7 of the appointed membership. With the section 1, it would be a majority of those appointed. So not necessarily the 20, but maybe a smaller number. I'm just curious. I'm just concerned. I guess I'm just raising the issue, and if you had considered that number could drift much smaller if the seats are going unfilled.
So thank you, Representative, for the question. That I think could be a concern with any one of these bodies, and being able to recruit volunteers and keep them actively engaged. And I think one of the barriers that has been there has been the size of the groups and the quorum. So it could start to, yes, I think it could start to dwindle down. But my position on this is if we actually straighten out this quorum issue and get these groups meeting again, regularly doing their job, that we will fill every seat. And if we can't, then I actually think we have to do what we've done before, is look at the composition of the membership and make a decision about whether that's still working. It's a very good point. Thank you.
Okay. Any other questions? Seeing none, thank you for your testimony.
Thank you. Always good to see you. All right.
And Whitney Hammond.
I was going to say good morning, but it's not. Hello. So my name's Whitney Hammond. I'm the interim deputy director for the Division of Public Health Services. I'm here to speak in support of SB 190. And I wanted to just provide a little bit of context on both the Interdisciplinary Primary Care Commission and the State Health Assessment and State Health Improvement Advisory Councils. These are both groups that I serve on and am a member of. Both are intended, as Senator Prentice had said, to convene broad membership with statewide representation. The goal of the Interdisciplinary Primary Care Commission is very focused on primary care healthcare workforce. And so it's very important that we have participants from rural areas of the state where we tend to have some of the biggest workforce issues for primary care. And then the State Health Improvement Plan, for anybody who hasn't seen it, is a much broader plan that's focused on health and well-being, again, statewide. So both commissions have pretty large memberships because the intent is to be representing everyone from, furthest north to south, east and west, and then a lot of different disciplines. So the Shawship Council has members from the Attorney General's office, from healthcare facilities, from public health networks across the state. And so we have great membership with regular attendance, but oftentimes the attendance is done virtually via Teams meetings. So it's great because we do get a large number of those members to participate. But again, we're not able to do our formal business. So it's oftentimes hard to approve meeting minutes and to be appointing official chairs. We did, at least within the Shawship Council, we recently dropped down to bi-monthly meetings to try and improve participation in person, and that has helped somewhat. We do always include a Teams invite and record the meetings and post those for public participation, as well as sharing that Teams link in advance. But it is definitely this option, this bill would enable participation from our partners who would have to travel quite a ways to get to Concord. I'm happy to answer any questions about either of the Primary Care Commission or the Shaw Ship Council, if there are any. Thank you.
Okay, are there any questions? Apparently not. Thank
Thank
you
you.
very much for your testimony. All right. Is there anyone else who wishes to testify on Senate Bill 190? Not seeing any, I'll close the public hearing and go into executive session. Does someone have a motion?
Yes, Madam Chair, I'll move auto pass on Senate Bill 190.
Is there a second? Representative Pearson seconds. Okay, thank you. You should speak to your motion.
Sure. I think that having large memberships in commission is challenging. I sit on a Seacoast commission with a large membership, and we need 12 people for a quorum, and we have to hold our breath as to whether or not 12 people are actually going to show up, because some individuals are, they are either in Concord here, or they are located at their office, which is not convenient to Portsmouth. I understand the issue, and I think that if this is a workable solution, then I hope that it does promote activity with your council. I wish you luck.
Representative Pearson, do you wish to comment?
Thank you, Madam Chair. Just in the sense that, if we're going to have if these councils are going to exist and they're going to do decent work, they have to be functional. And as we've seen through the OPLC and other boards where we've had to make changes with alternates, we've had to make changes with accessibility and whatnot. If we don't start adapting to the realities of today, we're going to have all kinds of problems here. So this is a small ask to make this thing work. So I fully support it.
Thank you. Representative Leon?
Thank you, Madam Chair. While I appreciate this moving forward, I think that in-person meetings are very important and very vital to doing the business that is important enough to be put into statute. We have many, many very important commissions and committees. I'd actually put these ones pretty close to the top of the stack in the healthcare area. But I'm very troubled about the idea of moving away from in-person meetings. I know that they are challenging. I know that logistically there's problems, but those conversations that happen and those relationships that you build and the way that you can address an adjacent situation with somebody when you run into them on the way to the meeting, I think adds as much value as what happens in the meetings. Quite frankly, I think part of the reason it's a problem is because we have too many committees and commissions, and that's not something that can be dealt with easily. I know a term or two ago, I think last term we tried to address that and didn't get very far. But I think that moving to making meetings with able-bodied people remote to this extent is a problem. I supported moving some of the disability groups to more of a remote attendance because you're dealing with people with you're dealing with some of these communities where they truly would have no representation if they weren't able to get out, because the problem of transporting people with some of these injuries is such a burden that they will have no voice. I don't see that as the case in either of these committees. And while I appreciate what's trying to happen, I think that we need to stop moving away from in-person meetings. I don't know how the will of the committee is. I know that Section 1 to me seems very, very important with a council this large. The difference of 1 or 2 people by having it be a majority of those appointed versus 20 could be the difference between functioning and not. So I would be supportive of Section 1, but I just can't make more meetings remote. More and more I see the value of these other conversations, and I just can't vote to make more meetings remote. So thank you. So I will be against an OTP motion. If we decide to deal with this at a later date, I'll get an amendment to strip out sections 2 and 3 to see how that would work.
Representative Reese, and then Howard.
I'm in favor of, I will be voting for the OTP motion. I think this is practical. Our state is large, and in order for us to accommodate the schedules of the kind of talent that we want on these committees, we need to make sure that it's accessible. And I agree with you, actually, about the in-person meetings being important, but if it's slowing down the work and the substance and the quality of people who can join, I think that this is something that we can move forward with and readjust in the future if necessary.
Representative Howard. Okay. Yeah. Anyone else? Representative Sellers.
Thank you, Madam Chair. I'm concerned about the quorum myself, and I don't want to see just 1 or 2 people showing up. I mean, it's hard enough. It's hard enough for hearing people over Zoom or WebEx and trying to have them participate, raising their hand or getting their attention. And at least when you're in a meeting, at a meeting, you have the ability to wave down the chairperson or someone else. I'm just concerned that you're not going to have hardly any people showing up. And that to me that's my concern. And I don't think like this section 2 is, if it was said, 40% or 45% make up the quorum, something like that, but 1/7, that's just too small.
Representative Broda.
Well, I just want to remind Representative Sellers that 1/7 of 23 would be 7 people. So they couldn't have the meeting unless there were 7 people there, right? 1/7. Oh, hang on a second. I've got it backwards. Sorry. 3. Sorry.
Yeah. Representative Reeves.
Yeah, I think that we heard the testimony about the math on that it was for Shawship, it was 6, 1/7 being in the room. And still a quorum has to, or what we would traditionally define as a quorum, 50% plus 1, still need to be part of the meeting. And then for the other, which I didn't get the flashy acronym for, but Shawship stuck with me. But the Commission on the Interdisciplinary Primary Care Workforce was 4 in the room out of 23. And I just think that we have to keep in mind that just because somebody is not in the room does not mean that I would not equate that to them not paying attention, nor would I equate somebody not being in the room to their not being able to use simple technology like Zoom if they're joining that way. These are people who are, I believe, who are highly competent. That's why they've been recruited to set state policy and move discussions about our workforce forward. I think that the easier that we can make it, and I believe that getting people in the room is a good thing, but the easier that we can make it for talented and busy people to join something that helps to move our state forward, that we should do that. And if right now they are not able to meet or they are not able to have votes because they cannot get a quorum, that is problematic.
Okay, Representative Pearson.
We have billion-dollar corporations that conduct meetings remotely now. It's 2025. It's time that we get into the now with this and make these boards functional again.
Yeah, I would be concerned about the getting enough people together to actually do what they're supposed to do is probably more important than insisting on the physical connection. Although, how often do these groups meet, and how long are the meetings? I mean, that's. Yes, thank you. I would very much like to know that.
The Interdisciplinary Primary Care Commission meets every month, and they meet for an hour and a half. And the Shawship Council meets every other month, and they meet for an hour.
Well, I can see why somebody might not want to drive an hour and a half in order to go to an hour-long meeting. So that's a
And I
concern.
might add, Madam Chair, that some of these people are professionals who have jobs and who may see patients. I mean, some of them are in the medical field, so they're not going to be able to take the day or half a day off. I mean, that's also important too.
Okay, Representative Schmidt?
So I have a similar question because I'm not nuts about Zoom meetings, but I participated in them all the time because otherwise you don't have the people involved. So what kind of availability do you have of people who can't make it physically, but who are on the Zoom?
So, so we use Teams for both those meetings, and we generally get more than the proposed quorum that is being discussed today that actually show up in person for meetings. And then we've worked very hard at the department to support both the commission and the council to be using the Teams technology to be very interactive. So they use the chat feature, they use the hand raising feature. And again, these groups have actually been around for a fairly long time. So they have met in person as whole groups. So it's not like a first time meeting where you're joining virtually.
Thank you. Follow up, and then Representative Howard.
So the thing is, I'm not familiar with the specifics of the Teams concept, but the thing is, so if you didn't have to have everybody physically present to have the quorum, you have a real vital workaround with people who are physically or virtually there when you got a large number of the overall group. Is that the case?
Yes.
Okay, Representative Howard?
Thank you, Madam Chair, and thank you for taking my question. Just a little clarification. Are all of your meetings held in Concord?
For the Interdisciplinary Primary Care Commission, I think the answer is yes. They're generally held at the New Hampshire Hospital Association building in Concord. For the Shaw Ship Council, we've historically met in a couple of different locations throughout the year. We generally try to have one at least like Meredith or north of Meredith. And we do, that one is intentionally attended in person by the full council.
Okay, thank you.
Thank you. Representative Leon?
Thank you, Madam Chair. I think you bringing up the issue that a lot of people have worked together for a long time actually brings another question to light. The question is more around what happens when somebody new is mixed into this group of people that have been working together. Just as background, I worked with a senior analyst on a two-person analyst team for about 7 years remotely. We were never able to bring anybody on to work with us because you couldn't really integrate somebody's work style if you had worked in person together and you have that relationship. So it's just a shorthand by working remotely. And then somebody new is added into the mix and you don't have that same in person. Kind of like how, for those of us who were around 3 terms ago, trying to work as a committee when we were meeting over Zoom was an entirely different dynamic now that we are here together and in the room. And I'm just worried about the future functionality too if we reduce that in person, because you won't have those relationships between important stakeholders all throughout the state that are built through participation in these, and people that may not otherwise get to know each other and work with each other. They'll have this virtual connection, but they won't have that more important human connection, which actually helps the healthcare network within the state function. So I understand both of the arguments, but I just really see the in-person value. But I also won't, I wanted to bring that previous experience and the idea of integrating new people into an established group to the forefront, but I don't think I need to discuss this position any further.
Representative Saitek?
One of the annoying things about being up here is when you see both sides of the argument. And that's really, I don't enjoy that at all. The idea of somebody who you've never seen this person and there's just a face on the screen. Of course you want just their ideas, but somehow I like human beings. And so I wish you had something in here like twice a year you actually had to have a real everybody there to see, that this is not Rumpelstiltskin, that this is real. But I'm not, look, I guess I'm going to go along with you on the grounds that we have people who are in the arena doing this, they're not going to want to try to dilute or minimize their efforts. They've thought about this, so I'll go with the recommendation. I wouldn't mind, although I don't think I want it right now. I don't know what these people do, what these two councils are all about. It's the first I've ever seen these words, and I hope they do something useful.
We all hope that they do something useful. Representative Leon, you have some information?
Yes, in my previous personality on Health and Human Services, we did see that they do in fact do very useful things, and they are very important.
I'll take your human being voice.
Okay, anyone else have a comment? All right, yeah, I agree with Representative Leon that in-person meetings are important, and I was very glad to hear that the council tries to have at least one in-person meeting every year, but I'm certainly not going to vote against this bill because of that. All right, anyone else? Okay, the motion is ought to pass by Representative Grota, and the clerk can call the roll.
Vice Chair Leon,
No.
the clerk's going along with him, yes. Representative Pearson.
Yes.
Representative Bailey.
Nay.
Representative Sheehan.
Yes.
Representative Sellers.
No.
Representative Slotky.
Now you're really going to make me pick. No.
Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative Tiberis.
Yes.
Representative Long.
Yes.
The chair?
Yes.
Okay. 4 in the negative means 11 in the positive.
Sure, you
All
got
right,
4.
then
I counted 5, but maybe I'm wrong.
Voting nay were Leon, Bailey, Slotky, and Sellers.
All right. The motion passes 11-4. Does someone wish to write a minority report?
I'll write one unless one of the others wants to write it.
I don't think you'll get anybody objecting to that. Representative, okay, so Representative Leon will write a minority report.
And I'll write it as not to pass as amended by stripping out. I'm going to write an amendment to strip out sections 2 and 3 from the bill because I think the change in quorum in section 1 is very important.
Okay, thank you.
So-
That's all right. And Representative Grota will write a majority report. And that is it for today. Committee, we are meeting Wednesday and Thursday next week, and that will conclude our public hearings for Senate bills. And hopefully we will only have one meeting after that for a final exec session. And thank you all for lasting through today.
Also, to the licensing subcommittee is going to meet Wednesday at 11.
Okay.
Okay. So we're here anyway.